tell you I can see the finish line. And I'm very happy to know that very, very soon, the Jamaican people will have an operationalized legislation that will not only seek to prevent sexual harassment, but will also offer the necessary protection to victims. I want to say to committee members and to the technical team whose guidance at this juncture is critical, to the Hansard writers, to the committee clerk, to the IT team, to the Houses of Parliament staff, and to the public who has been watching us and monitoring us for the part they have played in being an integral part of the process. So at this point, having gone through all the clauses, we went back to the definition section of the bill. And today we resume our deliberations on these definitions. I know that we received correspondence from former acting ombudsman, Mr. Makulo. And at today's meeting, I would like to share what he has submitted with the committee. And I'm hoping that it will not unduly delay us, but that in fact, since he has taken the time to submit his comments, I think we should take the time to look at it. So I will ask Ms. Grant maybe what we should do is complete the definition section. We should complete the definition section of the bill, and then I will ask Ms. Grant to speak to us, read the submission from Mr. Makulo. So Ms. Grant, you're there?
I'm here, Minister.
All right, thank you, Ms. Grant. Could you proceed?
All right, afternoon, everybody. So we resume today still on Matrix 1. We had looked at lastly suggestion made by Jamaica Aid Support for Life. So where we're picking up today is the comment made by the Ministry of Tourism. And as we agreed last meeting to go through them one by one. So this is what Ministry of Tourism proposed. They proposed that the word unreasonably would be deleted from subsection B1 of the sexual harassment definition, which reads interfering unreasonably with the work performance of a person to whom the sexual advance is made, as it could give rise to a defense that the interference was reasonable. So I will stop there, Minister. I'm not sure what comments the members might have.
There. All right. So if there are no comments there, we Ms. Grant?
Yes, Minister. So it's for us to decide if that suggestion is worthy of adoption or we're leaving the definition of sexual harassment as.
Yeah, members? Well, I think we...
Is anyone talking?
Yeah.
I'm not sure. Is someone speaking because I'm not hearing, so I'm wondering if my instrument is defective.
You wanted to make a comment, MP Bounder?
No, I just wanted to say that I understand the reasoning being put forward and would agree with the recommendation.
All right. So do we adopt? Do we adopt this, or do we keep what's the position of the committee? Minister?
Sorry, Chair, could I just ask Ms. Grant to just advance to us again the reason that they had put?
Sure, Senator. The reason they had put for why they are suggesting that the word unreasonably be deleted from the definition, because they say that it could give rise to a defense that the interference was in fact reasonable.
And so what they would be suggesting is that we replace unreasonably with?
Well, to have it deleted so that there is no reference to any reasonability whatsoever.
So how would it read?
Well, what they are suggesting then, it would read, if their suggestion is adopted, sexual harassment means the making of an unwelcome sexual advance towards a person by another person, which is regarded as offensive. Well, which is reasonably regarded as offensive or humiliating by the person towards whom the sexual advance is made, or B, has the effect of interfering with the work performance if you delete unreasonably. So it would be interfering with the work performance of the person to whom the sexual advance is made. Or
so, in other words, they are saying to us that the word unreasonable, you might have some, you'd have to quantify what unreasonably represents. Mm-hmm. So if we were to delete unreasonably, then there has been no cause or call to quantify.
Yes. That's what they're saying.
Okay, all right. So having distilled that in my mind, I'm inclined to go with them.
Yes, I think we can. So if we have the agreement, we can go with it. And Ms. Grant, go ahead, MP. MP Brownberg, you were going to say something?
Oh, no, I'm sorry. No. Right. I was saying aye.
Okay.
All right. She was exercising her right to vote.
Okay. That's correct. You know how we love to vote.
So we agree. And no.
Yes, we do.
Go ahead, Ms. Grant. Thank you.
All right. So we go to We Change, and this is the last suggestion made in Matrix 1, and these were what they had to say. That the inclusion of the definition of harasser a definition for who an harasser should be included in section 2, and that the definition should include third parties. They pointed to the U.S. Equal Employment Opportunity Commission as a guide, and that defines it says the harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or customer. So currently we don't have a definition for harasser. They're suggesting that we put it in, and we look to what they have here as a guide. They also proposed that we include online sexual harassment in the act, and for that to complement what already exists in the Cybercrimes Act. Indicated also that explicit references, if we are including that, identify the use of technology as a medium for sending or requesting pornographic images or other such material. So those are the two suggestions from We Change.
All right, well, let's look at the first one. Could you repeat?
Sure, Minister. So the first one is including the definition of harasser in section 2, and they're asking that the definition includes third parties. I'll just read what they put here to guide the U.S. Equal Employment Opportunity Commission, and that defines harasser as the harasser can be the victim's supervisor, a supervisor in another area, a co-worker, or someone who is not an employee of the employer, such as a client or customer. And I see Mrs. Seeley Brown's hand up, Minister.
Yes. Go ahead, Mrs. Seeley Brown.
Thank you, Chair. Well, I must first point out that harasser, Chair, is not used in the in the bill at all. And if you look at the scheme of our bill from part 3, what is being defined in the US model that was cited, we have set it out in the scheme of our. If it's a case where you would want us to, then we may look at adding to the scheme that we have here. That's fine, but you can't define a term, Chair, that is not used in the legislation, and we have not used harasser at all in this bill.
All right, so Mrs. Celia Brown, what are you suggesting specifically? What are you recommending in this case?
Well, we can't define a term that's not used. If it's a case where they say that we need to expand who can be sexually harassed in relation to the employee-employee situation, we can look at that. But we can't just include a term just for including its sake, Chairman. Because it's not used, we can't include it, but we can definitely expand the scope, which we had discussions on last week, Chair, of part 3 of the bill.
Yes. So we will expand the scope. Okay, Ms. Grant?
I'm assuming that when we say expand the scope is to also make sure we specifically include third persons. I remember there was a discussion around that before. I just wanted to be clear in terms of what Mrs. Celia Brown meant about expanding the scope.
Mrs. Celia Brown?
Chair, I'm trying to get my video to work. I don't know what's happening, Chair. My apologies. Yeah. Well, remember when Ms. Grant read it spoke to other instances of sexual harassment that's not outlined in clause 7. I think she spoke of. I can't remember the ones that she read, but I know it's a little wider than what we are proposing here, because we speak here, Chair, of an employer supervisor situation. We spoke of an employer, a prospective employer, and the person who is seeking employment, and we spoke of right. So it's employer supervisor, employee, employer, and coworker, and prospective employer. I think she mentioned some others that weren't set out in the draft. So if it's a case where we can adopt those, I take no issue with that, Chair. It's just that we can't use the term harasser because it doesn't fit within the scheme of our bill. It's not used in the draft, in the bill, sorry.
All right, thank you. So, Ms. Grant, you note those.
Chair, so more than one group who made a submission made a reference to the third party.
That's what I was asking, yeah.
And in the scheme of things, a third party, whether it be a client, customer, or even a subcontractor or someone offering service to a business, can be, quote unquote, an harasser. And in this case, what I think we ought to consider is how we can capture the third party situation in part 3 of the bill, or specifically clause 7. We don't need to mention, because harasser is not mentioned anywhere, but the inclusion of representing the possibility of being exposed to a third party, being an harasser, should be taken into consideration. And it was one of those areas that, again, I say, was represented by more than one submission.
So
I want to agree with the member, 100%, because it came up time and time again. And I thought that there were many members, myself included, who thought that we should include third parties and to make sure that that is clearly covered by the bill as well.
And so we agree that we will expand we will expand that area. Right?
Sorry, Madam Chair.
Yes, go ahead.
Just to check, we are expanding the scope of persons who can be harassed under this act, and by that we are saying that we will also be expanding the types of offenses or the types of sorry, I'm just looking at the offenses and the role of the tribunal. You know, I continue to consider, Madam Chair, the interplay between this act and the act that, or the amendments that will come to the Offenses Against the Persons Act.
Yeah.
And I just was looking, when we say that we will expand the scope, we are looking at the scope of persons who can bring an action for compensation if they have been treated in a particular way, that they can take their action before the tribunal to seek compensation for having been sexually harassed. That is, to have had an unwelcome advance, which is offensive or humiliating, even if this is something that has not, meaning, so they would be going under A and not where the effect has interfered with the work performance or created a hostile environment. This would just be the act of having an unwelcome sexual advance being made towards a person. That's what we're looking at expanding.
No, that's my understanding. Mrs. Celia Brown had made a suggestion that instead of defining who an harasser is, we could maybe look at expanding the areas where a third party or others could be seen, could be included. Am I right, Ms. Grant? Mrs. Celia Brown, that's what you were saying, rather than
yes, and I'm not advocating for the harasser definition. I am in agreement with all those who have said that they do not support including a new definition of a harasser. We're defining the act of harassment, and everyone seems to be fine with that. I'm just trying to understand what happens to the scheme when we expand the persons who can bring such an action. And I'm not disagreeing with it. I'm just trying to understand it so I see how it fits within the bill as we have it, or whether it is that it's something that should be dealt with elsewhere. I'm just trying to understand it fully. Sorry, Madam Chair, if I'm delaying the discussion.
No, you're not. Can I just go before Mrs. Celia Brown to explain my thought to Minister Johnson Smith? Yes. And I go back to part 2, clause 3, an employer shall make every reasonable effort to ensure that the workers employed by the employer are not sexually harassed in the course of their employment. Now, we have in place an employee who has to engage in this, conducting the services with a third-party client, customers. And so you want to make it that provision available to protect the employee where they are so exposed to a client or a customer coming in. Take a bank, for instance, and a customer comes in frequently and seeks to harass the bank teller. That bank teller must have an opportunity or an avenue to raise that concern of harassment. And the employer has a fundamental responsibility to treat with it. This is not confined now to the employer, employee, or co-worker, but the exposure to a third party.
Okay, thank you very much for that clarification. So I am a bank teller. A customer of the bank comes in and makes an unwelcome advance towards me. I should be able to complain to my employer and say that this client has made an unwelcome advance. What do I expect my employer to do? What do I reasonably expect that employer to do?
I expect the employer to take the necessary action in protecting the exposure to the harassment of the employee.
That's what I'm trying to unpack.
That action may be one to speak to the customer.
All right.
That action may be in a hotel situation where there's a guest.
You can go in your room and turn on the AC.
Senator Longmore, your mic is open.
That in a hotel situation where there's a guest.
Let's stick with this one for the moment. It
can be confined to this one when we're speaking generally of an employment situation.
But I'm asking to understand this one to understand how it would unfold in a situation which is not necessarily continuous. So yeah, like the hotel that you're about to mention, which is a little different because the guest is there. The guest will be resident there for a period of time, and one can therefore, but if someone is coming in, I'm not saying no, Senator, I'm just trying to understand what could we reasonably expect so that we understand whether we're properly providing for it here. Because is it a report to the police? Is it or is it that they must ask the person to leave, that they must call security? What is the type of action that would be reasonable for us to require? Because it is us who will have to educate the employers about what this means. And it is therefore, so we need to know what the act is saying and what we're agreeing to change.
And so, it would be a situation where in the first instance, that employer would be required to investigate the matter. That's the first thing. And we would expect and anticipate that they would have their own they may have their own internal steps to treat with it. What I'm suggesting, is that it might happen once, or it may lead to the possibility of a continuation of the act if it's not dealt with. And so that employee on the front line would be continuously exposed. Is the act prepared to treat with that? Because it becomes a reality.
Yeah. Right, so it's part of the system. So they have to be thinking not only about what they do in employee to employee or employee to employer. They need to be thinking about the environment, the work environment generally.
Generally, yes. Because workers have complained of this exposure.
Yes, okay.
And the challenge that we would have is if we are establishing a piece of legislation that is not seeking to cover that possibility that exists.
Yes. Okay, thank you very much, sir.
It could be a client, it could be a supplier.
It could be a supplier.
Yeah.
Chairman, if I may.
Go ahead.
Good afternoon, everyone. I'm wondering in the same breath regarding my previously raised concern in terms of the employee-employer. Even the scenario that was just described somewhat likens to that situation. And I go back to asking regarding, let's say, a contractor who has a construction site that has a female supervisor and has male or has a predisposed to that type of harassment from persons who they supervise. I am wondering again if we are broad enough in our scope to cover that situation of employee to employer. Thank you.
Any member wishes to comment on this? Senator Gale, I actually would like to hear your comments on this.
I believe that, Chair, I believe that will be taken care of in the co-worker to co-worker situation.
Yes, I think that was our discussion last week, if I recall correctly.
Yes.
Okay. Mm-hmm.
Thank you so much. So have we more or less settled on the matter that we were discussing previously in terms of the expansion of third party being
The scope?
included and the scope being expanded? Have we agreed? Are we agreed on that?
I think so, Madam Chair.
Okay, fine.
And if we are, then there is also the online,
Yes.
because recommendation also included online, and I think that is especially as the pandemic has shown, we are more online than before. I suspect for many of us, our screen time has increased drastically, and I do believe that this is an aspect that needs to be covered.
So, Ms. Grant, could you just go through that
Yes.
situation again? What is the proposal online sexual harassment?
The proposal is to include a definition in the act that complements what the Cybercrimes Act has, but there is some line of demarcation. And they indicated as well that there needs to be explicit references which identify the use of technology as a medium for sending or requesting pornographic and other such materials that are sexually charged.
I think, do I recall correctly that last week what we had agreed was that there would be, that we shouldn't try to narrow how the matter is dealt with. We must ensure that the language of the bill is wide enough to ensure that harassment occurs, however it happens, whether it is online or otherwise, and that there was no language in the act at this time that constrained that. I don't know if we want to start defining the actual sending and receiving of pornographic, for example, because it's really any unwelcome advance, any offensive or humiliating, it's any intimidating, offensive, or hostile work environment. I'm sorry, Ms. Grant, I thought it was dealt with last week. I could be wrong.
It probably was mentioned in relation to something else, but that did come up, Minister. And it would go back to the point that you just made about confining ourselves, boxing ourselves in a certain way.
Yes, I think what we had asked for was that the technical guidance ensure that the relevant definitions did not exclude the harassment occurring online. And I think the committee had felt comfortable with that they would have to indicate.
I see Solicitor General's hand up, and after that, Mr. Sibley's, SG.
Thank you, Chair, but Member Sibley's hand was up long before mine, so I feel I have to defer to him, and then I can speak, if you don't mind.
Okay, fine, no problem. MP Sibleys, please go ahead.
Thanks, Solicitor General. Thank you, Chairman. I just wanted to ask through you, Chair, Senator Gill, if he could explain how to treat with the situation of an employer and a third party in the context of what member from Central Manchester had put to us some weeks ago. Because I would just love to get a better understanding from an employer point of view. What are some of the things? What would be the minimum expectation of an employer? I heard Senator Gill said investigate as one, of the steps to take. But in terms of the example that was given by the member from Central Manchester, Ms. Crawford, where a member of the constituent came to the office and was saying to her and the members of her staff, of her team, what a sexy woman work here, which they had found very offensive. And Member Crawford would be seen as the employer. What would be the minimum expectation in a situation where is a member of the constituent that comes to the office? How do we treat with that?
And you want me to assist you in answering that? And I suppose you too would find yourself in that position being a member of parliament and an employer. And in the first instance, if we are saying that the employer shall make every reasonable effort to ensure that their workers employed by the employer are not sexually harassed in the course of the employment, in the first instance, it must not go unnoticed. If a report has been made by an employee that they feel that they were exposed to what an action that would have been unwarranted, then the employer in the first instance has a responsibility to respond to it. And that's what we're saying. No, we will not be able to treat with every single solitary situation. But when we spoke about supplementing this legislation with a guide, a framework that would allow an employer to look at that framework, look at that code, and to say, these are the steps we can take in treating with the situation. That is something that this piece of legislation is going to require as a complement to educate both employers and employees as to the scope of permissiveness. And that was my suggestion, that at all points in time, an employer would have a responsibility. In that case, member siblings, to say to the constituent, the member of the constituency, we do not accommodate that type of behavior here. And please resist from doing that in the future. Because out of respect for our employees, and from we start sending that signal, that is a clear message that these actions are unwarranted. And in sending that signal, it may very well shape and change the behavior of the society. So some of the things that we are seeing today can be prevented.
Yes, Senator Gill, and I am with you on that. And I'm sure every reasonable employer would take that step. No reasonable employer would allow anyone or to employ anyone to abuse his or her employees. But to my mind, I'm looking at it from an evidential base. Yes, I would have said it to that constituent member. But what is it that I would produce if, as an employer, I am accused of not doing enough? It would be the employer were to say that on the day I had said this to the member of the constituent. So those are the, I am thinking through the entire process to see, and I am with you with regards to the bill should come with certain guide to assist employers as to the minimum expectations that one would look for. But I am going on that to think it through, if based on the example that you would have stated earlier in responding to me, to say to the person, listen, you're not supposed to come here and treat my staff like this. You're out of order. Don't do it again. And I will have to prevent you from coming back. Yes, so I have done that. Having done that, a few months, a few years after, there's an allegation to say that I never, as an employer, never carried through what I ought to have. Where the evidence, my words against the employee. And that is where, unlike the employee to employee, supervisor to supervisee, where as the person which is reported to, I can do an investigation. I can also write, put it in writing, and send to the individual. Then I am creating that evidence base that I have not only spoken to the person, I have given them something in writing. And I would have documented the investigation and I would have gotten the responses from all the parties concerned. I am saying this appears to my mind, evidential case with regards to third party. And it is something that we shouldn't take out of the bill. I'm not suggesting that, but it seems to be something that really need to be looked at.
So I can understand my colleague that it is not that you're not finding merit with the fact that there's an exposure to risk with third party, but it's for us to find the proper way in treating with it. And in that situation where MP from Central Manchester would have indicated, the evidence only stand with a display from the employer at the time in the presence of the employee that an action would have been taken. And it may not give rise to you writing to that constituent, but the employee cannot deny that you never acted in the interest of the employee.
Well, my experience, Senator Gale,
yes.
My experience in the courtroom and is that very employee would come and say, my employer did nothing. And the employer is coming to say, but I did speak to the member of the constituent. And there lies my difficulty. There's absolute merit. We don't want suppliers. We don't want any third party. And we should not, no employer In fact, no member of your team should really sit by and not prevent a reoccurrence of such thing, distasteful thing. However, where I'm going with this, as I said earlier, is the evidence if that employer is accused of not doing something. And something that I will think through myself and make some suggestions. But I want to get it to the committee. It is one thing for us to legislate and say it, but we also should look at how challenging it could be to the court.
Well, I see where Senator Sophia Fraser-Binns, who have always agreed with me in these proceedings with her hands up. So I'm hoping that it's an expansion of my views. So over to you, Chair.
Yes, before I take Senator Fraser-Binns, Senator Campbell Rodriguez had her hand up just before. So I'll take her and then Senator Fraser-Binns.
Thank you, Madam Chair.
And please remember, put your video on because we're on PBCJ television.
Yes, sorry about that.
No
thanks for the reminder. In terms of this issue, I see what Senator Gale is saying, but what I'm concerned about is that it becomes such an onerous process for employers that it doesn't happen. And let us, Senator Johnson Smith, use the example of the bank. And what are we expecting the employer to do in that situation? And one of the things that we have to be mindful of is in a larger corporation, they can put systems in place to help. But let us use the scenario of the wholesale downtown, run by Miss Chin, and Marcia works in the wholesale, and one of the guys who deliver sexually harasses her. I don't think we can count on Miss Chin to act on that situation. And as such, Marcia has no protection. Is there something to stop? And I remember Senator Johnson Smith asked for what specifically do we expect? And I'd like to offer this as a suggestion. If the employee feels harassed in the workplace in those scenarios, for example, they report it to the employer. The employer then is expected to give one warning to the person who's doing the harassing. No, in the situation of the wholesale downtown, chances are that person isn't going to respond. What is preventing the employee then from going directly to the tribunal to report the situation? Is there something preventing that can happen? Because I'm just afraid that if we leave it up to the employer, nothing will happen, especially smaller businesses. So I don't know if that my suggestion is something that can be taken into consideration.
All right. Thank you, Senator Campbell Rodriguez. Senator Fraser-Binns, and then we can go back to responding to Senator Campbell Rodriguez. Okay.
Thank you, Minister. And I see MP Brownberg's hand is up as well. But I listened to the conversation between Senator Gale and MP Sibley's. And the first thing I want to say is that the question raised by Senator Longmore about the employer, using the example that he gave of MP Crawford, the question raised by Senator Longmore regarding the employer and how we treat it, I think is something that we may need to look back at. But in terms of the other issue about the employee and what is in place, I looked back at the Act and I see under Part 2, Section 4, that it speaks to the fact that the employer shall, in relation to the business undertaking of the employer, issue a policy statement in writing concerning the prevention of sexual harassment. And in my mind, a starting point would be that that policy statement has to be not just shared with the employees themselves, but with anyone who comes in contact with the employment. So your suppliers, your customers, they too should be aware of the policy. So whether it is something that you're going to have that's going to be inserted, or whether it's going to be an ongoing campaign, you know, I think we're going to have to decide on how we treat with it. But the knowledge is something that has to go beyond just the employee, but also with the third party, because it is only in that way I believe that they'll be aware of it. Secondly, in terms of the response, I don't think we can legislate specific response, because I do believe that a response will vary from a warning to an expulsion, to just tell somebody, don't ever come back on my premises, whether it's going to be the hotel or it's going to be the wholesale or the supermarket. We may have to do that. And I wondered whether, Minister, when this is finished and we start developing the manual, whether part of what we can do in the draft is to help the employers in terms of a graduated level of response. So you could start off with a first warning, maybe a second warning, then a suspension, and ultimately an expulsion. So that there is a clear understanding amongst all parties, the employer, the employee, and the third party, that if this happens, then these are the various responses that can be undertaken, depending whether it's a first offense, a second offense, or a third offense. And Senator Rodriguez, you spoke about whether there is something that we would be able to, well, an employee in a situation like the wholesale downtown, there is nothing in, again, from my memory of the act, that would prevent an employee from going to the tribunal, because if the employee says to Ms. Chin, and we call every Asian Chin, but if the employee says to Ms. Chin that this has happened and Ms. Chin, for whatever reason, fails to act, then the employee can certainly resort to the other alternative that is provided in the act for some kind of recourse. And I think that is something that we, as part of the public relations, will have, well, public education, will have to let persons know that though there are internal procedures, if they feel that those procedures are not being undertaken by the employer, then they do have a recourse to the tribunal for some kind of redress. Thank you.
Thank you, Senator Fraser-Binns. I'm going to take MP Brown-Burke, and then I'll go back to the Solicitor General, who sometime before had indicated she wanted to make a comment. Go ahead, MP Brown-Burke.
Okay, thank you very much, Chair, Minister. I just wanted to also add and to say I understand the concerns and therefore the discussions that we're having, in particular about how we would, well, the redress that could be mounted by the employer, in particular for third parties, especially if they are not regulars, you know. I believe, though, that we could not and should not allow the difficulty to prevent us from making sure that it is also included, because given the experiences out there and what we are trying to combat and reverse in terms of practices, I believe that this is a necessary inclusion. I suspect that, as Cavan likes to say, that we need codes of practice around these things, and therefore that would include some of the steps that could be taken. I also was wondering whether or not, in the same way you have a license or a notice that I've applied for a particular license, for example, whether or not we couldn't also have a seal or something that says, you know, we are actively promoting and working on ensuring that our employers, our employees, as well as our clients and visitors, are protected under the sexual harassment legislation. Couldn't be something that we also kind of promote. so that it is one way of saying, listen, this is active here. So, and I'm thinking also it's just as part of the public education as well, that some persons might come and sit and say, hey, what's that? And you have an opportunity to explain what we're doing, because I suspect that certainly in the beginning, as this legislation takes effect, it is going to require a number of activities, of interactions to just help with the public education, especially because, make no doubt about it, our cultural practices are what we're talking about does not fall naturally in line with our cultural practices.
Thank you, MP Brownberg. Solicitor General.
Okay, thank you, Chair, and thank you, members, colleagues. So the first issue I had, I actually was trying to get clarification on what was agreed by the committee, but it appears as if I'm not sure if there is an agreement in terms of how you treat with third party, because I was not clear on the agreement and what, if any, amendment is to be made to the bill, and that we would need to be clear on. But I see that the discussion is still evolving, so I guess I will wait a little bit for that answer. But there was also some discussion about online sexual harassment. I don't know if research was done by Legal Reform Department in terms of a comparative analysis, but just from an ordinary reading of the bill, there is nothing to preclude, or it doesn't state the manner in which the sexual harassment or the form in which it is to take. So, for instance, it could be done over the phone, it could be done by email, it doesn't have to be done in person. And so the bill, to me, doesn't restrict to an extent that you would have to know, provide for quote unquote online, because also that in and of itself is it's another arena. And I just wanted to point out, we would also want to be careful about how far you go up that road in this law, because from my own knowledge, a lot of the cyber related matters are criminal in nature, they're not civil. So if you look at the Cyber Crimes Act, which I know will be under review, and perhaps I think they may look to see what, if any, strengthening there needs to be in terms of, say, cyberbullying and all of that. Those are all criminal offenses, and those penalties are very harsh. Remember that this bill is quite different in nature. So again, I would suggest that from what I read in the bill, it seems okay, because it would accommodate, as I said, things like even things done over the phone, things done by email, and not necessarily in person. And again, I would also caution about trying to go far down that road of the cyber sort of issue, making it too specific here, because as I said, a lot of those matters are usually criminal in nature.
Thank you, Solicitor General. So I think in relation to the online.
Chair, I'm sorry. I see Mrs. Seeley Brown's hand up.
Oh, I'm sorry. Go ahead, Mrs. Seeley Brown. Sorry.
Thank you, Chair. Just to reiterate what Mrs. Aldred just said, an offense is an offense whether it's whether or not it's committed online or it's committed in person. So there's no distinction. The Act does not make a distinction between it's committed online or offline. Sorry, not an offense, sorry, an act of harassment, and we have to be careful. Cyber crimes, remember, those are criminal offenses, as Mrs. Aldred quite rightly pointed out. So, and this act deals with civil liability for sexual harassment. So we have to be very careful, Chair, when we're trying to make that cross-reference, or we're trying to link acts to the cyber crimes legislation.
Thank you, Mrs. Seeley Brown. Erica, Simon, Legal Reform, and I'm going to ask you to remember to put your video on when you're speaking. Go ahead.
Hello, Erica Simon from Farm. Just with regard to the whole online commission of the sexual harassment, no mention was made of my department. We hadn't done any specific research on it because we thought it was already covered in the bill. It's wide enough as it is drafted to cover the commission, whether it's online or in person. And as far as other jurisdictions are concerned, I have not seen in my reading only for online harassment in any other jurisdiction.
Thank you. Thank you so much.
Minister, because I was one of those who had said specifically that I thought it should have been included. I still hold the view, not that it should have been included, but that it is covered. I am satisfied, and since I said to the contrary earlier, I wanted to make sure I had it on record, that the fact that the language of the bill does not preclude online, I'm satisfied with that. And since we also seem to be saying in terms of the definitions that we have for sexual advance and sexual harassment, that those are also complete enough to cover what might be not otherwise captured, well, that would not have fallen under the cybercrimes. And I'm also okay with that, just to be clear.
All right, thank you so much, MP Brownberg. So it's clear to us regarding the online sexual harassment, and it does not need to be specifically stated in the legislation, but we're still a little unclear. We're dealing with third party, and the point that was raised, a wholesale, and if the person goes directly to the tribunal, I just want to make sure that the response to Senator Campbell Rodriguez is clear, and that we have addressed that particular matter in our discussion. So I don't know, Mrs. Cedar Brown, please go ahead.
Thank you, Chair. I would just like to draw the committee's.
If you don't mind, you putting your video on, if you don't mind.
Chair, I've been trying. Something seems to be wrong with my, I'm working from home today, and something seems to be wrong with my laptop. I'm not able to turn it on. I've been trying all the time. I'm still trying. I just wanted to turn the committee's attention. Sorry?
No problem at all. Please go ahead.
Are you hearing me, Chair?
We're hearing you okay. Please go ahead.
I was saying, Chair, I would like to turn the committee's attention to Section 28G of the Sex Discrimination Act 1982. That was raised by Member Rodriguez in relation to goods, services, and facilities. I can read it, Chair, and you can see how best we can fit it into the scheme of what we have now. It says it is unlawful for a person to sexually harass another person in the course of providing or offering to provide goods, services, or facilities to that other person. And subsection 2 of that section reads, it is unlawful for a person to sexually harass another person in the course of seeking or receiving goods, services, or facilities from that other person. So it widens it beyond the employer-employee scheme, which is what is discussed. I don't know if legal reform would be minded to do some research, because I've been trying to look to see what are the available remedies for breach of this particular provision, and I've not been able to see any, Chair. So I don't know if they can probably do some research and report to the committee as to what can be the available remedies if a matter like this would go before a tribunal.
Sorry, where was that one found? Through you, Chair. Apologies for just butting in.
It's Section 28G of the Sex Discrimination Act 1984 of Australia. Thank you, Chair.
Yes. Yeah, thank you, Mrs. Celia Brown. Legal Reform would wish to make a comment? Okay, all right.
Just that we will look further. Sorry, sorry, Chair. Just that we look further at the matter. I do believe I had looked at had seen that provision. I'm not sure if I'd seen a similar provision anywhere else, but I can double check and get back.
Okay. Okay, thank you so much. Ms. Grant?
Yes, Minister.
All right, so I think we can move on now. I think we're there to get back to us also on the remedy in the case of the third party and the expansion that is being recommended here now.
Yes, yes, Minister. That's what Ms. Simon said. So they will do research on the remedies and get back.
Right. I see Senator Longmore. You want to make a comment?
Yes, Chair. Thank you. I'm very sorry to cause us to probably recommit the sexual harassment definition. I've been sitting here thinking about it the whole time, where we had determined to remove unreasonable, if it has the effect of interfering with unreasonably with work. My question is around Part A. The definition of the sexual harassment is reasonably regarded as offensive or humiliating by the person towards whom the sexual harassment is made. If we remove unreasonable below and we keep reasonably here, who determines the reasonability? It is regarded by the person towards whom the advance is made as being offensive. Now, who determines that reasonability of that regard? Maybe I'm seeking clarification here. Is it the individual? Is it if the person thinks that it is offensive, but the mechanism in which they make the report, so the HR person, the employer, if they think it is an unreasonable regard, is the person going to have any resolution of the concern? Or if it is regarded as reasonable by the HR personnel, but not by the tribunal. What I'm trying to get at is the offense is a very subjective offense. So I'm wondering why reasonably is there. Maybe, like I said, maybe I'm not affair with the ramifications of requiring that legally for it to be reasonable, but it begs me to ask who determines that reasonability. Thank you. And sorry for going back, but like I said, I was really giving it serious thought to see if it warrants me bringing it up. Thank you.
Thank you, Senator Longmore. Anyone wishes to respond to that query from Senator Longmore? Ms. Grant?
Just to say, Chair, that by its very nature, it is, as Senator said, it is subjective. And so striking to the heart of her question as to who determines reasonably regarded as offensive, it would be for it's the victim's call that it's regarded as offensive to me. And so I'm making my complaint. I don't know if because she mentioned the removal of the word unreasonable, so juxtaposing the two, and the comment that was made there from the Ministry of Tourism was to say it could give rise to a defense that my interference was reasonable. So to take it out would nullify the use of that defense. But I don't think that reasonably needs to be removed.
Any further comments?
My question is not necessarily whether it is to be removed. What I wanted was a clarification that it is only the subjective person who determines whether or not. So if someone says, if I wear a pants, if I'm wearing an outfit and somebody say, boy, that look good for you, or something, and I go to my HR department and say that I found this to be offensive, does that automatically become a complaint on my part? Or is there a recognition that the HR or the other agencies that might be involved, whether the employer or so, may determine that it is not reasonable enough to warrant complaining?
No, Senator. Sorry, Chair. It is the person who initiates the complaint, who determines that it's offensive to me. Yes, and so it's not in the employer to make light of your complaint. Say, oh, it's nothing. They might feel that way, but it is you're the one initiating the complaint, and so to you, this is how it came across to you.
Okay. All right. Fantastic. Thank you. Thank you for allowing the clarification, Chair. Thank you very much.
Ms. Grant, could you proceed, please?
Yes, Chair. Okay, so we move on then to Matrix 2, the comments on the Matrix 2. So this is Girls Who Know, and they made this suggestion that we look at adopting a similar provision to what is provided for in Section 3, subsection 2 of the Employment Sexual Harassment Prevention Act 2017 of Barbados, which recognizes that harassment can be a single incident. So the section reads, nothing included in the definition of sexual harassment should be interpreted as precluding a finding of same when there is a single incident. That is what they said.
Yes.
I don't, as it's currently, as the bill is currently constructed, I don't think there is anything based on how we have drafted it that would preclude anybody from finding that you can only make a report where there is a series as opposed to a single incident.
All right, any comments here? Okay, so Ms. Grant, we will ask you to continue and no take, no comments here, so you could proceed.
Very well, ma'am. So Ministry of Education, Youth and Information. Well, we spoke at length about person in charge in our previous meeting. And I'm wondering, Chair, that probably this might not, because we had spoken about it and eventually agreed that any matter treating with children should be specifically provided for. But for what it is worth, I will read the suggestion nonetheless. It says they advocated that we introduce a definition for person in charge, as they recognize that this may be the terminology commonly used, but the person in charge is often an employee. In educational institutions, it is the proprietor or the managing authority, such as a statutory board, that has the power to approve institutional policies and take disciplinary action. So they suggested that we introduce a definition for person in charge in this context.
Wouldn't consider that necessary, however. Right? What are you recommending here?
Well, what they're saying Chair, is that in educational institutions, how person in charge is viewed, it's normally the proprietor or the managing authority, such as the board, that approves institutional policies. But if we decide to go along and use it, because the last conversation we had about at what point would the bill cater, would it be at the age of consent versus the age of majority, which we still have to eventually decide on. Definition of person in charge might not be necessary, because if my memory serves me correct, the reference to person in charge was, I think, as it relates to maybe places of safety. No, a person in charge of an institution that is 6'2", who fails to take. So they're saying that because it's used in the legislation, we should define it as to who a person in charge is. Is it the board? Is it the statutory body that makes the rules? Who is person in charge?
Any comments here? Cecilia Brown? SG? How would you guide us here? Any comments here? Any guidance? Ms. Grant?
Yes, Minister, I see.
Oh, I see.
Yes.
Minister Johnson Smith's hand up. Please go ahead.
Just coming in because of the silence, Chair. Sorry, but yes, just to say that I understand their concern, because the question would be whether, well, I think they would want to know if the person who is operationally in charge, or in charge of operations, as opposed to a broad policy decision maker, as a chairman of a board, for example, as opposed to a principal who is having a direct authority to make decisions about matters related to the operations of the institution. It may well be that in that sector, it might require clarification. So I would appreciate some guidance on that. I think that the words "a person who is in charge" sound quite clear in terms of the the ordinary meaning of those words. But if I don't know what the technical team feels, or not feels, what they think in terms of the need to make that any more sharp or clear in respect of the decision-making power, or the operation decision-making power, as opposed to policy making. Is that something that comes in guidance, or is that something that we actually define to say a person for the purposes of this section, a person in charge of an educational institution shall include, or would it be necessary in terms of the correctional services as well, versus the commissioner versus a warden type of thing? I would be interested to hear what they would say.
Senator Gale, and then I am going to ask Solicitor General or Mrs. Seeley Brown to.
Chair, my concern in this would be to take immediate and appropriate action. And it creates a real expectation on the alleged victim to get a response. Now, in this situation, where policy decisions or directives are given by maybe a board or another body outside of the person that is operationally in charge, it may frustrate the process. And so I would want the technical team to consider whether or not we really, against those circumstances, need to define the person in charge, so that we can have the possible swiftness of an action taking place and not waiting for a meeting of the board to make a determination whether there is action. So that would be my concern.
Thank you, Senator Gale.
Okay.
Who wants to take this?
Yes, sorry. Sorry, Chair, and sorry for the deafening silence. Sorry about that. But we're also doing a little consultation, and I just wanted to apologize on behalf of Mrs. Celia Brown, who is having technical issues. So she actually was bumped off the meeting and then had trouble reconnecting. And I see that she's back on, but she's also having difficulty hearing. So she has asked me to apologize, but we were actually discussing it while I was off camera. Looking at it, we do agree that there could be some clarity that could be provided, because it can be, so you took the example of a chairman of a school board or a principal, and who would it be? Now, granted, it's the principal who would be the one who could still take some immediate and appropriate action, but to an extent, so could a chairman of a board, because the chairman of the school board also can do certain things and has certain powers even under the Education Act. I think the concern I have is that we don't want one person to say, well, I thought the other person was going to do it. We don't want any deflection of responsibility. And so I think we would have to look to see if this could be a little more targeted and make it clear that there could be no deflection. So perhaps it could be both the chairman of the board and the principal, for instance, that should be taking action. But if you would give us a little time, and I know we're under a time constraint, I understand, but sometimes this is how things go. Chair and members of the committee, you look at something 4 different times, and then member Gale says something, and then your eyes open up wide and you realize there is a complete different perspective. So I'm just saying, in that context, if you would just allow us until the next meeting to perhaps provide perhaps a solution or an option.
Thank you, SG. I know Senator Gale opened his eyes wide, and then
thank you, Soljen, for saying it like that. That's why you're a Soljen. You say it better than me.
I could have said Minister Johnson Smith too, because she has that tendency. She says something and then you realize that you were looking at it from a perhaps even wrong perspective. So see, no, I can share it up.
The point is, that the way you represented it gives even us the opportunity that it needs to be targeted. And somebody needs to own the responsibility. And so that which would allow the action to take place. Yes. And to inspire confidence in the process.
Yeah. Yes, Senator Dale, thank you so much. SG, we're going to give you a couple of days. Thank you.
But I see that legal reform, Ms. Simon has her hand up, so maybe she actually has an answer.
Maybe she has an answer. Yes, please go ahead.
No, I don't, but I just wanted to mention that the same issue that is being raised for the institutions, I think, is also there for certain places of employment where that kind of added clarity is needed, because the way employers define some places of employment, you would not be able to readily identify who the employer is either. I just want to raise that as another issue.
All right, so you have a couple of days, team, to come back to us. We're really on the wire now with our deadlines. So we're really looking forward to you coming back to us with some clear guidance. Ms. Grant, thank you so much. Ms. Grant?
Yes. I'm sorry though, sorry to interject, Ms. Grant, but just to help to guide us. Would the committee, so in the instance that the circumstance I raised in that it could be a responsibility, say, for both the chairman of the board and the principal. Is that type of direction the committee is looking at, or is it that you would prefer for it to be, again, in that situation, say just one person?
I think, well, I don't know if I'm reflecting the feeling of the committee, but I would say both. What do you, any comments here? I think silence means agreement. So SG. So we have our silence.
Yes, you see, I'm no kind of thinking about like a university where you have, so UWI has UHWI has a, sorry, not UHWI, UWI has a charter. You have campuses in different jurisdictions. Yeah, I'm thinking that it may not just reside in just one person's, it may not just be one person or one, one person's responsibility from that perspective.
Yes.
Okay, so we'll just have to look at it a little deeper.
Yes. All right. Thank you so much, SG. Ms. Grant?
Yes, Minister. Still continuing on Ministry of Education, Youth and Information. One of the things I mentioned was the unwelcomeness in the decision. I'm not going to really go through that comment. Why? Because it speaks to how do you define it in the sense of a child lacking capacity, and we have already decided on where we're going to go with that.
Ms. Grant?
Yes, ma'am.
Could you give me a minute, please? I'm just checking your same message from Senator Campbell Rodriguez. Don't know if it's an old message. You're not able to raise your hand, but you wanted to make a comment.
Thanks, Minister. That was before, and I had it sorted out, so I'm good now. Thank you.
All right, go ahead, Ms. Grant. Yeah.
So we would not need to consider that anymore, since we had agreed that matters concerning children need to be treated with specially. One of the other things they said was that hostile environment, they don't see where it currently applies to institutional settings, but it only seems applicable to work environments. And so they're suggesting that we consider extending hostile environment harassment to include institutional settings.
Yes, are we agreed on this, or your guidance there, Ms. Grant?
I am just thinking about it. I've been thinking about it since I saw it. I don't know if I necessarily agree with this, because the definition as it is, allows for it. The definition of what sexual harassment is, it's composed of interfering and has the effect of interfering or creating an intimidating, offensive, or hostile work environment. So I am not sure that I agree with this. I think it's already covered by virtue.
Okay. Everyone agrees here?
Madam Chair, I am not 100% on, and I would just ask for some clarification on the point. In respect of, my initial reaction was exactly that of Ms. Grant, but then if it speaks to a hostile work environment, so it's not interfering with my work. Let us say I am a ward, or so it is not, but it is, I'm harassed every day, and it is not, so the environment is one which is intimidating, but it is not a work environment, because my presence at the institution is not one of work. Let's think of it in an educational institution as well. I'm not a teacher, so I'm not, and my teaching is not being interfered with. Mm-hmm. I'm a student, so I'm not working. Oh yes, we said we're dealing with, well, let's say I'm a student, but I'm an 18-year-old student. I'm a 19-year-old student at university, and I'm harassed. So the environment, every time I go to class, I am harassed. Let us, so in that situation, is it that we do need something more beyond a work environment? Or is it that once it is not about interference with your work, the question is not about the environment in which you are, but it is about the offensive and humiliating nature? So is it that you choose the path? So once it's not a work environment, then all that it is that there is something that is regarded as offensive or humiliating. So you don't have to prove that the environment is offensive. You just have to prove that the advance was unwanted, was offensive or humiliating. And if so, you know, would it then be just a matter of evidence and building your case for compensation, where you would add information about the environment, but it would still be actionable under A? So I'm thinking as I speak, unfortunately, so it might not be as coherent as I might have wanted, but it's because my initial reaction was exactly the same as Ms. Grant's. I'm just wondering whether we need to expand it, or the choice is really made whether you go under branch A or B.
We need to look at it. Senator Gale, thank you, Senator.
No, I agree with Senator Johnson Smith in terms of looking at it, because even if you're a student and the environment becomes hostile because of this, it would lend to the fact that that student might become rebellious in nature.
Yes.
And feel intimidated, or may want to react in a particular way. So I can understand where the institutions are saying, don't limit it to work environment, but treat it as an environment in dealing with an environment on a whole. Thanks.
Thank you, Senator Gale. Mrs. Celia Brown.
But I'm thinking, Chair, it can actually, it's A or B. So it's either the advance is regarded as offensive or humiliating by the person towards whom the advance is made, and you can stop there, or you can go on to prove that it has an effect of interfering with your work performance or creating an offensive or hostile environment. So I'm not seeing, I'm seeing where it can be either one or the other. So you can, if you prove that this unwelcome unwelcome sexual advance is offensive or humiliating, you can make a complaint. And if you have further evidence to show that this advance has affected the way in which I have worked, then you can have evidence of that can be put before the tribunal. So I'm not understanding why we would need to expand it, Chair.
Okay, thank you, Mrs. Celia Brown. Ms. Grant?
Yes, thank you, Chair. I think what they're saying, Mrs. Celia Brown, is because B2 says creating an intimidating, offensive, or hostile work environment. So strictly construing what the term work environment. So they're saying in institutions, for example, if a student is subjected to sexual harassment, then it wouldn't properly qualify as work, but it could create a hostile environment for that student. So in such a case, they're saying, instead of saying hostile work environment, just say hostile environment.
Yeah.
And that's where I'd want to go.
Sorry, Senator Gale, but I think that is leaving it very wide, and I'm saying, Ms. Grant, that the student who is bringing that complaint can easily just go under A. When you speak of just a hostile environment, and then the sexual harassment is limited in some instances to institutions and employee-employee relationship and accommodation, I think just saying a hostile environment might actually be a little more difficult to prove.
I agree with you.
Yeah, because I'm saying that it's what Senator Johnson Smith was saying a while ago. You can go on the A, right? And you can take your matter before the tribunal, right? Because it's either or. And if you have evidence to show, any additional evidence to show that you have been affected on the end of the limbs of B, that's fine. But I think it is fine as it is, because that student won't in any way be locked out of an award or a claim if he or she makes a complaint to the tribunal because A is wide enough. That's just my take on how it's.
So let me ask a question, because in B1, interfering with the work performance of the person, so it would impact my work performance. I cannot deliver. I have not been able to make targets because of the environment to which that it has created. It is the same thing for the student, that the student may say, I don't have the ability to learn because of the environment.
What we're saying, Senator Gill, that the student doesn't even have to go that far.
Okay.
I'm saying that the student can easily fall on the A and make that claim on the A, because it's not A and B. It's not that you must prove that.
So the B then,
that you must prove that it's affiliating and has the effect of interfering with your work. It is saying that it is that or that.
Okay, so the B then is the B then is making the connection between 1 and 2. So 2 would support 1.
And it's yes, and it's still yes. It's either yes. But I'm saying that it doesn't lock out a student or somebody who is a member of an institution if they only go on the A.
Okay, fine.
Okay.
Yeah.
Thank you, Mrs. Celia Brown. Senator Johnson Smith, your hand is still up. You had a comment? Senator Johnson Smith?
Senator Johnson Smith is known to have a firm hand, you know. It's difficult to go down.
Chair, may I just add, I'm looking at it, I'm just thinking, if we remove work from B, I'm asking the members of the other technical team to weigh into, don't you think that it will be too wide? How do you interfere unreasonable with the performance of the person? I'm thinking it would be a little too wide.
So if I may, Chair, I agree that you would have to have some other qualifying word.
Yes.
You couldn't remove work, but you could add. So maybe you could add, meaning you would want to make it clear then that it's either the environment at work or at the institution. That's the other option. But you couldn't remove, I don't think you could remove work because it would be, the context would be lost.
But my thing is, Marlene, if because A is so wide, and if you're making a claim, you can fully make a claim by just reference to paragraph A. Paragraph B is basically more icing on the cake. If you have evidence to show that this is done, but it doesn't say that if you stop at A, you don't have a claim for sexual harassment.
I don't want us to take out work and then it water downs where you can have an added advantage in promoting the case.
I think it will be more difficult for the person who's bringing the claim if you just speak to a hostile environment where
maybe the work and institution.
Sorry.
So it maybe should.
You can add it, but I really don't think it is necessary because of how widely crafted paragraph is, Chair. That's just my view. Yeah.
I also think if you're going to change B2, you would have to reconsider B1. So I know that B1 it's not conjunctive. There's also an or between B1 and B2, which means you can prove one and don't have to prove the other. But I still think there is a link. And I think if you're going to do any kind of alteration to B2 in terms of the word work, you'd have to look back at B1, which also speaks of work performance.
Agreed.
Yeah.
But like I'm saying, Chair, I really don't think there's an issue with it as it is, because claim A alone can successfully land you a claim against sexual harassment.
Chair, I must say, if A alone can land us the supporting arguments in terms of applying to the tribunal, then I don't think we really need to expand it to create for the institutions. because the institution is really speaking about the students. Everyone else in the institution is a worker. And so B would treat with that.
Yes.
I agree, Chair.
Yes. So it will remain.
I'm sorry, Chair. So to be to throw something into the mix, do you think you could have a situation where only B applies and A doesn't apply? Because that's the only time you would then perhaps need to think of making a change to B. If you think that there could be a situation where the sexual harassment is only having an impact on your environment, but it's not offensive or humiliating.
But then, SG, it will have to be offensive and humiliating to be sexual harassment.
Okay, well, so if that is the answer, then I don't think you would need to make any change to B.
Because that is the whole element of sexual harassment, that you say something or do something to me that I find to be offensive or humiliating. So
that's A.
Yeah. Yes. Yeah.
But then
But remember, Chair, we have also, sorry, Senator Gill, remember we have also defined what is sexual advancer, and sexual advance is very widely defined. And sexual harassment is the making of an unwarranted sexual advance. And look at how widely defined sexual advance is on page 3 of the bill.
Are we recommending then that it remains as is?
Well, Marlene has, sorry, the SG has kind of tried to spoke in my village through, Chair, because of how we have divided it into the paragraphs and the subparagraphs. Because when I'm looking at the other definitions in the other jurisdictions, it just runs as one, you understand? So there is no paragraph A or B. And I think maybe that is where we're having some challenges, because of where we have placed A, and maybe A needs to be part of the shop, or be, I can look at it again. It could be that we can just create, just let the definition run on, so there's no limb created that is creating that sort of ambiguity among some persons who are looking at it. That's the only thing.
So Mrs. Seeley Brown, A indicates the trigger that the individual finds the advance offensive. What B does now is to further qualify the extent to which it has created a further effect.
Correct.
And is only seeking to support the argument. So A can stand on its own, but when you appear before a tribunal, B is suggesting that this now raises the level of the impact.
Sorry, but isn't it an or between
further
A and
supplemental argument?
But that's the
Isn't
problem.
it an or between A and B?
Well, that's the problem I'm having now on looking at it again, because the trigger, I think A paragraph, because if you read it without A, it says sexual harassment means the making of any unwelcome sexual advance towards the person by another person which has the effect of. So it doesn't speak of offensive or humiliating. And so my thing is, even though sexual advance is so widely defined, I think what makes it sexual harassment is the fact that it's regarded as offensive or humiliating. And that's why I'm suggesting maybe a redraft of the provision and not break it out into paragraphs, but let it run on as how it's done in the other jurisdictions. Just let it run as one definition without the difference.
Let it flow.
Yes, so that, because I think now on looking at it again, the reasonably regarding as being offensive or humiliating is a thing that makes it sexual harassment. So
right.
That's
a trigger.
Yes, that should apply to both A and B. So we should just probably make it run on as one definition rather than put it in these subparagraphs that creates a little confusion as to.
Madam Chairperson, Madam Chair, sorry, I can't raise my hand again.
Thank you. So we're going to come back. I see Senator Longmore and Senator Campbell Rodriguez.
Yes.
I'll take Senator Longmore and then Senator Campbell Rodriguez. And then we're going to come back to a final position on this as being recommended by Mrs. Cedar Brown. So,
well, my comment, I'll yield to Senator Campbell Rodriguez. My comment would be after you have come to a final conclusion. Thank you on this.
Yeah. All right, Senator Campbell Rodriguez.
Thank you so much. I just wanted to go back to that discussion being led by Senator Gale and Mrs. I think it was Celie Brown. I disagree needing A and that B cannot stand on its own, because I do not think, I think if the act interferes with your work performance, it shouldn't matter whether or not you're offended or humiliated, because I don't know, but it doesn't sit well with me that we don't think B could stand on its own. So it would remain as written now, you know, because the or there, I think, is what makes it where each stand on their own versus removing the or and letting it flow where you need A before B is applicable. I believe as written now, it is better, because you don't have to be, something doesn't become as sexual harassment, an act of sexual harassment because I'm humiliated. It is what it is, whether or not I'm humiliated. And I think if we change it, we lose that.
Okay. Well, as drafted, that was the intention when it was crafted in this way, Chair. So if that's the decision of the committee that you think it can stand alone, I have no issue with it.
Well, just to say though, which is because that was a question I'd asked, if it can stand on its own. So if B can stand on its own, then I really do think that it shouldn't just be work environment then. I think it should be either the work environment or the environment at the institution.
And I agree with you on that point. And that is part of the reason it needs to stay as it is, so that it gives it more depth.
So
more breadth.
And then Chair, how do we deal with accommodation? If we're going to include institutions and work environment, remember we have that other in clause, sorry, I think it's clause 9, right? That speaks to accommodation. How do we then, if we're going to reconcile work environment and institutions, how would we deal with accommodation? That would just go on the A. We would just leave that as being something that could be dealt with on the paragraph A. In the meantime, I'm looking at the other definitions here to see if I could offer any more guidance as to how we can proceed.
Give you and the SG a little time to just look at it again and come back to us. I would ask Senator Longmore to make her input in the meantime.
Thank you, Chair. Yeah, just as a guidance with regards to probably what we want to cover is in the memorandum of objects and reasons, and perhaps we can just use one embracing terminology to cover rather than to singularly list the workspaces or the accommodation spaces. Maybe we could say place of functioning or functioning environment, etc., because that would cover all. But Chair, I just want to go on officially recorded that I am seriously having, especially after listening to this conversation again, with the inclusion of reasonable, because it makes, if it is entirely based on the subjective experience of the person who is the target of the offense, it is regarded as offensive. I don't see why there needs to be reasonable. And my concern with this is that you can have an individual who is inexperienced in employment, who is intimidated by the process of making a complaint. And just the mere use of the word reasonable and the fact that it might be deemed unreasonable removes the subjectivity of that regard by that person. So, you know, I will always go with be guided by the legal luminaries. But in my mind, if it is regarded as an offense, I don't see the need for reasonably regarded. And I just want to just put it on record that I have serious reservations, especially with the discussions that we have had just now, where we had, I mean, Senator Gale mentioned the individual finds the advance as being offensive. The student in the classroom who may not be as au fait and as confident in recognizing their own experience as being offensive. It is, I think, once it is regarded as being an infringement on that they should be able to make a complaint. Thank you, Chair.
Thank you, Senator Longmore. Senator Campbell Rodriguez, were you?
Yes, thank you. Thanks, Madam Chair. I was supporting what Senator Longmore just said, and it is something I'd raised some weeks ago. The use of reasonably in A and unreasonably in B. It's to me, the subjectivity is something that we should reconsider. So I'm supporting her comments.
Senator Gale?
I wasn't going to comment, Chair, but look, I've always, where you have these policy statements that make provisions of words that persons can quantify, will always have a difficulty. And maybe what we need to look at, is there any harm in just removing the word?
Mm-hmm.
I mean, the absence of that word or words like those does not, it would not create any harm in terms of the effect that we're seeking to achieve.
Yes, reasonable or unreasonable. Mrs. Grant, Ms. Grant, you have a comment here?
Chair, just to say, I will look on the whole reasonability aspect and get back to the committee, and just to remind the committee as well that we had agreed based on a prior submission that we would remove the word unreasonably from B1. But okay, so I will get back on it, Minister.
Okay, good. All right, thank you. So while we note what we're going to get back on.
Thank you, Chair. Thank you.
Yes.
Sorry, just to clarify, because I was just having, I'm so sorry, but having a little sidebar with Mrs. Seeley Brown on how the definition of sexual harassment is structured. Are you now considering whether or not reasonably should be in paragraph A? Is that the issue?
The issue is they're not so sure, they're reconsidering.
Ms. Grant?
Well, that's a suggestion on the table, Solicitor
Right,
General.
okay. Because Mrs. Seeley Brown and I were speaking, because she was looking at some other jurisdictions. And again, it's a policy decision of whether or not you include this whole aspect of the unwelcome sexual advance being offensive or humiliating. So it is in some jurisdictions and it's not in others. And that's a policy decision, which is now reflected in ours, where we have it as one limb, but not, you notice it's not tied to B. So it is just one limb where it could be offensive or humiliating, or then you have the work performance and hostile work environment issue. But again, just to point out, it's not in every jurisdiction. What's in A is not in every jurisdiction. And we were just discussing, again, based on the question that I asked even before, it could be that you have an unwelcome sexual advance, but it may not have been offensive to you, but it was unwelcome.
Yes.
And the issue is, once it's unwelcome, is it that in and of itself should be is that sexual harassment then? So it's an unwelcome. Someone keeps sending me photos of their private parts. I don't want that. I don't want that to be sent to me at all. It may not offend me, but I just don't want it sent to me. And if I keep telling them stop and they keep doing it, is it that we're saying that that would be sexual harassment?
Well,
I mean, and I think because there are jurisdictions that don't include the offensive or humiliating aspect of it at all.
No,
Maybe Mrs. Seeley Brown can explain it a little better than I can.
yes, and also, Chair, there's some jurisdictions which do not include the reasonableness either. It's just a wide definition of unwelcome sexual advances against a person. But as Mrs. Aldred was saying, it's a policy decision as to whether or not we are going to stick with it being reasonably regarded as being offensive, or we just define unwelcome sexual advance wide enough to incorporate all the things that we like what we've done in section 2, and not necessarily requiring the person to state whether or not it was reasonable. Because when I'm looking at 2 other jurisdictions, Chair, and I'm seeing one where in Australia they speak to it being offensive or humiliating or intimidating, but none speaks of any of it being reasonable. The person has to reasonably regard it as offensive. That was taken, I think, from the Belize legislation, which was from the CARICOM precedent. So it's a policy decision as to how the committee would want to move ahead with that definition.
All right. Well, what I want to do is take up Senator Fraser Binns, whose hand is up. I'll ask Mrs. Coburn Robinson afterwards at the policy level to make her comments, and then I'll take Senator Longmore. All right, Senator.
Thank you, Minister, but I believe that Senator Longmore wanted to say something before me, just before I raise my hand. So I'm not sure if
Longmore has been commenting on this matter.
Okay, thank you, Minister. Minister, I just want to say that I too support the relooking of this provision, because when one speaks, in general law, when one speaks about reasonable, we talk about the man on the JUTC bus, for example, putting it in Jamaica. And the whole issue of sexual harassment has to do, it's a very subjective thing. And so when you open it to a man on the JUTC bus, determining if something is reasonable, then it takes away the power of the victim, because the victim now becomes subjected to how his or her employer or how his or her supervisor deems the action in his or her opinion. So I do support the position of removing the word reasonable in this regard.
Thank you, Senator Fraser Binns. Senator Longmore, you want to comment? Then I ask Mrs. Coburn Robinson to come in, and I see MP Brownberg, you're going to have to slip away now. So thank you so much for coming.
Yes, Minister, I'm going to have to run.
All right.
But just to say that my position remains the same as before in removing the reasonable or the unreasonable under both circumstances.
Okay, noted. Thank you.
Okay, thank you.
Right, Senator Longmore.
I yield to Mrs. Robinson, Minister Chair. Thank you.
All right, Mrs. Robinson, I'd like to ask you to comment here. Mrs. Robinson? Mrs. Robinson? All right, I'll come back to you, Senator Longmore, until Mrs. Robinson picks up.
Well, I'm just, it is for me especially, and I think we're kind of coming at a consensus here, but especially for the persons who may feel as if whatever offense or whatever it is that they're feeling might be disregarded. So, I'm quite happy to hear the discussion that has been had subsequently. Thank you.
All right, thank you. Mrs.
Chair. Oh, Mrs. Robinson is there now?
Yes, but go ahead, Senator Gale.
No, I just want to say, that in all that we do with this legislation, the definition of sexual harassment is the most integral part of this legislation. And if we don't get it right, we may open up all kinds of worms or people throwing a spanner into the works. And I just think back in terms of this term reasonable, and put myself in the mind of the tribunal, that when somebody may argue in front of the tribunal whether or not it was reasonable to contemplate, and for the tribunal to determine or make that determination. So I'm saying, if we take the word out of it, what is the harm?
Yes.
What is the harm? And maybe the Solicitor General or Mrs. Seeley Brown or Ms. Grant can explain to us, if taking it out, what would be the harm that may be created, if any.
Yeah, Mrs. Seeley Brown, go ahead.
I really don't see any harm, Chair. It was just, as I said, it was the policy decision that was taken at the time, because I'm looking, for instance, Chair, at the St. Lucia Employment of Opportunity and Treatment in Employment and Occupation Act. And sexual harassment is just defined as unwarranted conduct of a sexual nature in the workplace or in connection with the performance of work which is threatened or imposed as a condition of employment on the employee, or which creates a hostile working environment. Mind you, this just deals with the workplace, but I'm just reading it to say to you that there's nothing there about that the person was prove that it was reasonable. It's just unwarranted sexual conduct of a sexual nature, and that is defined basically like how we have defined sexual advance in our legislation. So it's a policy decision really as to whether you want to introduce that aspect of reasonableness or not.
Mrs. Rob, you were on. You're listening. All right. So I will ask Mrs. Robinson. I'm sorry,
Chair. Just. I'm so sorry to do this. It's just that I suspect. I'm not saying it has to be there, but I suspect the reasonableness was included because this bill goes a lot farther than other legislation. A lot of other legislation deal with it in the workplace. This now deals with the environment in an institution, and it also deals with accommodations. So this bill is a little expanded. So I think it was perhaps because of the expanded nature of this legislation why it may have been introduced. But my take on it is it could be removed.
And just to add to that, Chair, Mrs. Aldred is right in that regard, but I'm even looking at legislation coming out of Australia, and theirs is way more expansive than ours, and they do not speak to reasonableness. So I guess, as I'm saying to you, it's a policy decision as to whether you would want the tribunal to determine that, or once you define what is sexual advance or unwarranted sexual conduct, it should be enough to initiate a claim of sexual harassment. So it's obvious, yes.
I'm so sorry, Chair, if I could just interject here to support what my colleagues have said, and that I was looking through legislation here, and at least the 4 that I have gone through so far do not have the inclusion of the word reasonable. And so I agree with them. I don't think it wouldn't be an issue if it is taken out. And well, I'll leave Mrs. Robinson to speak on the policy aspect.
Yes. Thank you, Ms. Grant. Mrs. Robinson?
Thank you, Chair. So in terms of my take on it, and just speaking on behalf of the Bureau, I concur with the guidance from the Solicitor General and from the other legal persons in terms of the fact that there might be some amount of subjectivity if it is that it has to be that persons can make that determination prior to sending that report to the tribunal. And so in not to have the report quashed or minimized in any way, I believe that I agree that it can be removed. If there's going to be any reason to have a diminishing or a trivializing of the report, and to have the victim feel as if they're not going to get justice, or it's going to stop somewhere before being advanced, then I believe it can be removed.
Mm-hmm. Thank you, Mrs. Robb. I see Senator Longmore wishes to now comment.
Yes, Chair. Thank you. Just moving a little bit ahead, to reconsider now B2, where we had that issue around creating an intimidating, offensive, or hostile work and the limitation with work there. Could we possibly consider hostile habitat or hostile domain? Because I think either of those words could work for in the school setting or in the landlord-tenant relation situation. So just in terms of, instead of limited to work environment or removing work, leaving, maybe we could use habitat or domain, just offering those two as possible solutions there. Thank you, Chair.
SG or Mrs. Celia Brown, can you guide us here?
But Chair, I agree with the expansion of the concept. It can't be just the work environment, but Mrs. Celia Brown is really the drafter, so she would be the one to speak on the language.
Yes. Thank you, SG. Mrs. Celia Brown?
I would want to do some more research on that to see what are the best words we can use to incorporate the other aspects before I comment anymore on it.
All right. Did we settle the term unwelcome? Or are we going to keep what we have here? Are we going to do further research? Ms. Brandt, what was the decision here?
Well, Chair, based on my notes and based on what I remember, I don't think unwelcome had ever come up for discussion. If anything, it was a central thread, or it is a central thread running through quite a lot of the jurisdictions. The issue really seemed to surround unreasonable versus reasonable. And given what Mrs. Celia Brown has suggested, that probably the best thing would be to let the definition run as opposed to separating it, which is what we currently have now. I think that should solve quite a bit of issues, but we did not raise anything, at least not based on my notes and my memory, about the use of the word unwelcome.
Okay, so we can move on. Thank you.
So Chair, the final decision is to remove reasonable.
Well, the understanding I have is that would be so.
Okay.
It does not impact on the policy position. There is no objection to that being removed based on the advice from the Bureau of Gender Affairs. Am I right, Ms. Clark?
Yes, Minister, and the crafting of the definition itself too might change. We also spoke about that.
Yes.
Question, just from my understanding, Minister, did we agree that we'd let it remain as is, where A and B can stand on their own, or are we going to make them run into each other, where one is dependent on the other? What was the decision on that?
Well, I think did you want to repeat what you have there as your notes?
Yes, Minister, that we had agreed, Senator Rodriguez, that day we were going to let the definition run in, because that was creating quite a bit of discussion, as in A versus B and how that would. So it was said that we'd look at it and we'd come back to the committee. That's what I have. SG, I don't know if you have anything different.
No, I don't think so, because there was a lot of discussion on B standing on its own. I don't think they should run on, but it's a policy decision. At the end of the day, that's what I was trying to say. It is a policy decision, but I do believe that there is value in having B standing on its own without A, but that's my own, it's not a legal position, no, that's my own personal position when I look at what a sexual advance is, and I look at the fact that if it's unwelcome, in and of itself, it should be able to be sexual harassment, and that is supported in other jurisdictions. But the fact that we have competing, or we have different jurisdictions doing different things, this is why at the end of the day, it would now really be, it's not really a legal decision, no, it's really for the committee to decide whether they want to have A along with B, or you have A separate from B.
Right.
And
Minister, if I
as
may.
written now, they're just to confirm, make sure we're all on the same page. As written now, because it's an or, they stand on their own. Am I correct?
Right, they are disjunctive, right?
Okay.
And it will be a policy decision if we change that. And the Solicitor General did cite an example that something could be unwelcome, such as someone sending their parts on a phone to someone and they just don't welcome that. Ms. Robinson, I don't know if you were following that part of the conversation.
Thank you, Chair.
For you now to make your input here.
Okay, thank you, Madam Chair. So in terms of the definition, we've had several conversations with the public. We've had several consultations, discussions around how it is that we would define sexual harassment and how it is that we would ensure that the definition is crystal clear and all encompassing enough that there is no doubt when a claim is made of sexual harassment, there is no doubt that it is in fact sexual harassment. So the way it appears in this part of the bill, where you have is reasonably regarded as an offensive or humiliating by the person to whom the sexual harassment is made, or has the effect of interfering with the work performance, creating an intimidating, offensive, or hostile working environment. I think it should remain as is because it gives room for all types or all forms of sexual offenses based on what is reported, so that there is an adequate capture and coverage for it, so that it is not diminished in any form, or there is no opportunity for it to be swept under the rug or trivialized by any person at any point.
Kavon. Thank you, Minister. I know you had stepped away and I was actually calling to Kavon, who is the Deputy Essential. But I'm so happy I spoke after Mrs. Goldberg, because that was exactly was my position. I don't believe that it should be changed. I think as it is now, we have to, at all times, we have to remember the victim. And we have to think about the trauma that the victim would have gone through, and whether by legislation or by having to establish certain things, we're making it even more difficult for them. And I think if we were to make it a joined three-tier thing, then what would happen is we're making it more difficult for the victim. So in this situation, I think that as it is, it does no harm. In fact, it makes it easier. It strikes the balance. And there's sufficient, in my mind, there's sufficient safeguards in the act that will protect the harasser. But in this instance, as it is now, there is no need to change it. And I wanted to just state my position that I support it as it is. Deputy Essential.
I agree with you.
Senator Longmore?
I am in full agreement, Chair.
Senator Campbell Rodriguez?
Absolutely, absolutely in agreement that it should remain as is.
So we are at one then.
Well, at two in this case, yes.
Ms. Barnes, please.
Okay, so just to make sure, the definition is to remain as is, but we're removing reasonable and unreasonable, right?
That's my understanding, and I support that. Yes, both things.
Very well. So then we move on to.
Well, Ms. Grant, let me just get confirmation from the Solicitor General and that settled on that and there are no concerns.
I have no concerns, Chair.
We will proceed, Ms. Grant. SG must be consulting otherwise.
Okay. All right. JCTU made a proposal. I will read it, and if you will allow me, Chair, just to give my bit on it. They propose that we define the term worker as person conducting a business or undertaking, and that we should include corporate entities, companies, partnerships, and employers, as well as individuals exercising the authority, duties, or responsibilities of an employer. They also propose that we add a definition for the word workplace. And these were the suggestions made: public and private spaces where they function as places of work, places where a worker is paid, takes a rest break or a meal or changing facilities, and employer provided accommodation and transportation, work-related trips, events, training, and social activities. Just to say, Chair, that going to the first part of the suggestion about defining the term worker to include what they have suggested, the definition of a worker as we have it, Chair, does take in quite a lot of what they are already proposing. It takes in public and private sectors, and as such would include the corporate entities, the companies, the partnerships. It takes in a person conducting a business or an undertaking. I don't see, Chair, any need to change the definition for worker. That's me. And then the proposal to include the definition for the word workplace. I remember, Chair, in previous meetings, what we had said that to narrow, especially in, I believe it was maybe the last meeting, especially in this borderless society within which we operate, where the workplace does not necessarily mean the four walls, that to do so, to define the term workplace would be to so confine us. But these are the two proposals they made, and just putting it out there, Chair, for discussion and consideration as the case may be. So I don't think it warrants.
Cecilia Brown, please go ahead.
In addition, Chair, workplace is not defined. I mean, workplace is not used in the legislation. So we can't define something, that term that's not used in the legislation. And I agree with Ms. Grant's comments in relation to the definition of worker. In fact, I think our definition of worker goes much further than what they're suggesting. And then we even have the catch-all in paragraph I, which says a person or a class prescribed by the minister for the purposes of this definition after consultation with the minister with responsibility for labor. So we can always add, as the minister has a discretion to always add to that a definition of worker as he or she sees fit. So I think it's actually wider than what they are recommending, Chair.
Thank you, Mrs. Cecilia Brown. Anyone else wishes to comment? Or we can proceed to the
Chair, I will just say that we had extensive discussion in terms of treating with the workplace issue. When I look at the definition for worker, it is quite expansive, and I believe, save and except for I, which is in this one, there's another legislation to which we're working on that defines worker. that is extensive. And maybe what we need to do is to take this definition and apply it into all legislations that define worker. This is very expansive in my mind.
Thank you, Senator Gale. All right, so Ms. Grant, please continue. Please continue.
Just give me one moment there, Chair. Continuing on, Chair, it would still take us to where we just passed, but I'll mention it nonetheless. Household Workers Limited recommended that workplace be defined to include private homes or households, and we have already crossed that way. So that's fine. PSOJ, this is going to take us back to the definition of sexual harassment. It may or may not elicit discussion, but I'm going to read exactly what they suggested. They recommended that the definition of sexual harassment be expanded and amended as a sexually based violation of a person's human rights, including in a context of unequal power or gender relations. It may be one unwelcome, sexually determined behavior as physical contact or advance, sexually colored remarks, showing pornography, and the sexual demands, whether by words or actions, direct or implied, over a series of persistent, pervasive occurrences or a single serious incident by another person or persons. 2, it may be unwelcome, sexually determined behavior in exchange for a benefit or to prevent a detriment, and or 3, a sexually hostile environmental condition made up of persistent, pervasive conduct or a single serious incident. Such conduct may be degrading and may constitute a health and safety problem. That was the recommendation made by the PSOJ in relation to the definition of sexual harassment. That it be expanded to take in those things.
That sounds like a definition with experience of handling such matters.
Chair.
Yes, go ahead.
One of the things we should guard against is the creation of a definition that makes the application of the entire issue too complex, in that it may pose challenges for the person who is reporting it. It may pose challenges for those who may investigate, and it may pose challenge and loopholes for those who have to adjudicate. And so I am not one who would support a definition in this case that makes it too wide and complex, and so people have challenges in navigating. I think we have had a good discussion in terms of defining it, and we will just await the feedback from the technical team in terms of anything that can complement and support that which we have discussed. What the PSOJ would have done is to, highlight the extent and the gravity in which a sexual harassment can take place. But I don't believe that we ought to make the definition so complex in nature. That's my opinion.
Thank you, Senator Gale, and I think we all agree. Ms. Grant?
Yes, Chair. So that will take us.
Ms. Grant, Senator Long wanted. No, you're fine.
Oh.
I see your hand. No. Okay, fine.
Yes, sorry, it was an error, Chair. Sorry.
Okay, fine. Go ahead, Ms. Grant.
That will take us. having finished then the definition section, Chair, I don't know. We have the general recommendations to go through, which are not very many, really. I don't know, Chair, if you'd want to revisit those other clauses in the bill which we had placed in the parking lot during our discussion before we go to the general recommendations. I see Mrs. McCarthy's hand up and Miss Simon.
Mrs. McCarthy, we may want to look at Mr. Makulu's letter and his comments. You want us to do that at this time?
Good afternoon, Chair. I was just bringing back the committee to initially there was a proposal for immediate and appropriate to be defined. I didn't hear that raised. In the first meeting, we had the first virtual meeting. It was Senator Gale had asked that I look into the minutes for the discussion on the proposal from Jamaica It's support for those two. Having checked it, after they made the presentation, there was no reference to that in the discussions, but I don't recall it being said in our discussions today or last week.
Okay, Ms. Grant?
There was also a proposal from Mrs. Mesado for a definition or for consideration of a definition for the phrase business or undertaking of the employer, which is referenced at section 41A. Mrs. Seeley Brown had spoken at that time also about a discussion on that phrase under another bill that was before the Parliament.
Okay, so Mrs. McCarthy, you're saying that we about the immediate and appropriate, that we're supposed to define it? That was suggested.
Yes, it was suggested, and also Mrs. Masada mentioned the business or undertaking of the employer. So just those two that I haven't heard.
So I see Ms. Simon, legal reform, hand up, and then I'll go back to Ms. Grant.
It was just something I'd wanted to raise with regards to clause 27, potential issue that I saw. I don't know if now is the appropriate time to raise it.
Yeah, you can go ahead and raise it.
Okay, it's clause 27 says that an investigation is triggered where the tribunal thinks that the claim is well-founded and is not frivolous or vexatious. But my thought was that in some cases, it may not be readily apparent whether or not a claim is frivolous or vexatious, and that a provision should be there so that if that comes up at a later point, that the investigation or the tribunal proceedings can be discontinued. And I've seen similar provision in Belize like that. Belize includes a phrase in their provision to accommodate that.
All right, so what that phrase would be?
Let me just find it. Section 12 in the Belize Protection Against Sexual Harassment Act. They include the phrase, their phrase is, the court may decide not to carry out investigations, or as the case may be, may decide to discontinue any investigations. So I'm just thinking that we should have may decide to discontinue any investigations in there, in our section 27.
Okay, fine. All right, so no objections there.
I'm sorry, Chair. I just wanted to make sure that I got it correctly. So, Ms. Simon, you're saying that it would just be an insertion of the discontinue any investigations into clause 27?
Right, just in case, I'm saying based on particular facts or circumstances, it doesn't appear to them right away that the claim is frivolous or vexatious, it appears to them after the investigations have commenced, then we would insert that so that they would be able to discontinue the investigations that they would have already started.
Oh.
And you understand what would be inserted there, Ms. Grant?
Yes, Minister.
All right.
Okay.
Thank you, Ms. Simon. Miss McCarthy, you have other comments?
No, Minister, I'm sorry, I forgot to take my hand off.
Okay, fine. So, Ms. Grant, you were to follow up on the matters raised by Ms. McCarthy.
Yes, Chair. Well, we had 5 was part, so that would take us back to 5, where we had said that we would, that's what Mrs. McCarthy was saying, that we would define what is immediate and appropriate based on a suggestion that was made by, I think it was JTech, about what constitutes immediate and appropriate. 5.1 reads, an employer shall take immediate and appropriate action to deal with the sexual harassment of a worker of the employer, where the employer becomes aware of the sexual harassment. And it was agreed in a prior meeting that immediate and appropriate would benefit from a definition. And since we're on 5, just to say as well from my notes that what I have here is that we also, so we were to revisit the minutes to see what we had agreed on. And I think that's what Mrs. McCarthy was pointing to. But we had also agreed on in relation to 5 was that we need to create an offense for failure to act in respect, the failure of an employer to act in respect of 5, clause 5. And so to redraft clause 5 to include a penalty and to increase, to make that penalty stiff for the employer, where the employer fails to act, having become aware of sexual harassment. So those 2 things in relation to 5.
Okay, fine. All right, so you continue, Miss Grant.
Yes, Minister. So it then it's for us to, for the committee to make a decision as to would we want to do that, define what immediate and appropriate is to mean, especially as it relates to clause 5, and what would such a definition look like? Would it like the technical team to do some research and come back, or how are we going to approach it?
I thought we were going to, the technical team would do some research and get back to us on that from the time that.
No, Minister, what was agreed, which is why it was passed, was that we were to revisit the minutes to see what the committee had decided, if at all, about that clause, and then we would take it from there. So having looked at the minutes, this is where we are now.
Right, so I will take Senator Campbell Rodriguez, then Mrs. Celia Brown.
Thanks, Minister. I just wanted to say, I think on this one, I agree that we need to define immediate and appropriate, but I think I personally could use some guidance as to what other jurisdictions have done and how this is defined. Because off the top of my head, I would have said within 7 days, but I don't know if that's in itself is a reasonable thing.
Okay, thank you, Mrs. Celia Brown.
I'm in agreement with Mrs. Rodriguez Campbell, because when you define words in legislation if you don't want them to have their ordinary meaning. And when I look at the immediate means instant, prompt, swift action, and appropriate means what is right. So unless you want to put a time frame on when this complaint and when we expect the employer to act, I don't see how else we can define immediate and appropriate. Because in its ordinary meaning, it means that you must take swift, appropriate action at the time. So the only other thing we can do is insert, as Mrs. Campbell Rodriguez was stating, a time frame as to when that employer must act once he has that information. So that again will have to be a policy decision that will have to be made by the committee, because I don't think defining immediate and appropriate would assist in any way. Barring a time frame,
immediate and appropriate means the action must be taken within 14 days of him becoming aware of the claim, or 10 days, 7 days. I don't see how else we can define immediate and appropriate to mean anything else.
So would you want to take some time, do that research and tell us how, if that is so?
No, but I don't think we need, but what I'm saying, I don't think we need to necessarily do research, because immediate and appropriate means just what it says in the legislation. He must act promptly. As I said, the only other suggestion, in some jurisdictions, you have a time limit. You have within 7 days of becoming aware, you may have within 14 days. Is that the route that you want to take? So you pin the employer or the person who has received this complaint down to a particular time frame, having regard to maybe whatever other circumstances we may need to have regard to. But short of not stating a time frame, immediate and appropriate means just that. As soon as you get this complaint, you must deal with it.
But in terms of a time frame, what is done in other jurisdictions?
Oh, I can't remember what I'd seen. I don't know if legal reform can weigh in on that, Chair, but I can't remember what I'd seen, if I'd seen a particular time frame. I think Belize used the same immediate and appropriate action, and I think that is what was in the CARICOM draft. I stand corrected on that. But separate and apart from that, I don't see how we can define immediate and appropriate to mean anything else.
Legal reform, you have a comment here? Thank you, Mrs. Celia Brown. Legal reform?
No, I'd have to look to see if I see any timelines. To my recollection, I did not see any jurisdiction setting a timeline, and Mrs. Brown is correct. I do see the immediate and appropriate being used in Belize. I'd have to look some more at that.
Okay, Mr. Sibley's, MP Sibley's, you wanted to say something?
Chair, I was just thinking that immediate, what is there, to my mind, is appropriate and probably is used by a number of jurisdictions for a good reason, because a number of things can affect, and if you put a timeline, it may give persons, say you put a timeline of 3 weeks, a person may wait for the end of the 3 weeks when they should have acted within a day or two of getting that report because of the seriousness of these things. So I don't know if to put a time, but for it would, on each case, you'd have to look and see what would be immediate based on the circumstances.
Thank you, MP Sibley's. I'm gonna ask Mrs. Robinson to make a comment, then I will take, Mrs. Celia Brown, you wanted to make a comment? Or your hand is just up?
Oh, Chair, I'm sorry, I should have taken down my hand.
Right. And Senator Longmore, legal reform, you want to make a comment, Mrs. Simon?
Just one quick comment. I was looking at, I'm not sure if this is a part of law or if it's a draft bill, but in Barbados, there is the Employment Sexual Harassment Prevention Act. And they do use a timeline, but their provision is a little differently drafted than ours. It says that the employer, where the complaint is lodged with the employer shall commence an investigation of the complaint within 14 days of the complaint being lodged and shall complete the investigation, without delay.
Okay, thank you. I will ask Mrs. Robinson to now comment, and then I'll take Senator Longmore and Senator Gale. Mrs. Robinson?
Thank you, Chair. In terms of the timeline, I think there are times when having a timeline might be a little onerous for the victim, because in some cases, for example, the time that you use to make the report, we have had cases where the case is reported way after it happens, and in some cases the investigation starts way after. We believe that if it is that it's an urgent case, when in all cases a case that is made against for a case that is made of sexual harassment is in our mind extremely urgent, we believe that it is something that should be done immediately. So if it is that it cannot be done, then the idea is that it should be done as quickly as possible. So I'm not so certain if having a timeline would be the best way, because it might give persons an advantage to say, I have that amount of time to do it, or if you don't make the complaint within a certain time, or if I'm not bound to act at a certain time. So I believe that based on how we define sexual harassment, it is egregious and it is immediate. And the person who is suffering from that harassment wants action and wants justice and wants follow-up immediately. So I believe that we should, when we're thinking of timelines, as long as it doesn't interfere with the ability of the person to make the complaint and the responsibility of those persons carrying out the act to do their duty, then I believe we have to be very careful how we look at timelines. It should not affect the ability of the person to get justice. And it should not create a situation where the person who receives a report believes that they can wait and decide when to start, because you have to think of the psychological and all the other impacts of the person who has made the complaint and who has received that act of sexual harassment.
Thank you, Mrs. Robb. I'm going, Senator Rodriguez, you, Campbell Rodriguez, you wanted to make a comment earlier?
Yes, I was just saying that given what I think Mrs. Seeley Brown said, in terms of it can only be a time frame and the responses which have come since, I think if we can agree here, for example, I would suggest that if an employee makes a complaint to an employer, or whether it's in an institution, a student to, you know, whomever is in charge, that within 5 to 7 days, because if we don't put a time frame, someone can sit on it if they choose not to. Let us look at a scenario. Mary works for Mr. and Mrs. Brown, and it's Mr. Brown who makes, you know, who sexually harasses her. Mrs. Brown has no reason to want to necessarily deal with this matter, and she can keep giving excuses. So I think if we say 5 to 7 days, that's a reasonable amount of time to have it done. I'm not looking at 2 weeks or 3 weeks. I'm looking at within a week's time for the matter to be dealt with.
Thank you, Senator Campbell Rodriguez. I'll take Senator Gale, then Senator Longmore, and I see Mrs. Seeley Brown and Ms. Simon, hands up. So Senator Gale.
Chair, I'm not inclined to go with a timeline, because I'm looking at it that the word immediate is that you must act with haste in treating with it. And I have the fear that when you give timelines, either you're going to be compelling all employers, irregardless of their situation, to act within that confined period. Or you may also, the fact that you establish a timeline, people ask for an extension. My concern in this is what would happen to those employers if they don't act, because they must act. And so I'm moving to that second part of it, to which I had suggested that there must be a penalty for not acting. So I'm looking at it as being the immediate act without, I mean, in haste to treat with it. I remember my submission.
But my haste and your haste may be different.
Well,
that's very subjective.
You can then accuse the employer for not acting immediately.
But then he could argue the case that his immediate and my immediate are different. Who determines? It's an individual determination as to what is immediate.
So you said between 5 to 7 days.
That's my suggestion, because I think by human nature, if you don't give us something specific to work with, it becomes very subjective and it can be argued. You get a good lawyer to go to court and argue about what is immediate. You can argue that I took 2 weeks to act as an employer or 3 weeks, and that for me is immediate based on X, Y, Z. And that's my fear, that it becomes so subjective. And I agree with you though, that there should be a penalty if action is not taken. But how do you determine when that action should be taken if you don't put a time frame in there?
Senator Campbell Rodriguez, note your comments. I know
Chair, if I may.
Senator Longmore.
Sorry, I think I've lost you guys.
You're on. Right
I'm on? Yes. Oh, sorry. Yes, okay. So my thinking is a little bit, and I recognize the need for the immediacy. Immediate and appropriate is actually, in my mind, two different things. We need the immediate action, but we need the appropriate action. In setting a timeline that is short, that reflects immediacy, could the extent of the investigation, the extent of the gathering whether other complainants are there, etc., etc. The appropriateness might be lost. Maybe what we should be looking at is appropriately immediate, and maybe having a circumstance where in the development of the policy, the regulations, we stipulate that upon the complaint being made, there is an immediate response that addresses, to whatever extent it is warranted, a response, but there is a certain time frame, necessarily the full extent of the immediate response, but there is a follow-up of the complaint being formally pursued. I don't know if I'm making sense, but I also share Senator Gale's concern with respect to, I would not want this to also be seen as a deterrent to the employers to act, or to encourage the reporting of circumstances that are offensive because of the immediacy or the extent of the appropriate response that needs to happen on their part within a certain time frame. So for me, I think there should be an appropriately immediate response with, it's like a two-tier. If whatever it is, there should be an immediate communication to the person who is the offender. But you should have time to adequately launch an appropriate investigation and subsequent reporting of the matter. Thank you, Chair.
Thank you, Senator Longmore. Mrs. Celia Brown, you had your hand up earlier in relation to this matter.
So, okay, Chair. I think Senator Gale was highlighting what I was.
Okay, thank you. Ms. Grant? Oh, I think I would want to invite Mrs. Robinson to just come back on as the person at the Bureau to again put her perspective on the matter of a time frame. Mrs. Robinson? Because
yes. Can you hear me, Minister?
I can hear you, but
okay, because I keep dropping in and out. My internet is unstable. When I look at the section 5, which says an employer shall take immediate and appropriate action. I believe that that's fine because that speaks explicitly to the duty of the employer to take immediate and appropriate action to deal with a matter that is extremely important. So I believe it should be retained and remain as is.
Okay, Senator Campbell Rodriguez, you heard the perspective of the Bureau. I just wanted us to be at one in this, in this particular matter. Senator Longmore, your hand is up. You still want to make a comment? You want to make another comment?
No, Chair, sorry. Did not lower my hand, sorry.
Minister, I'm sorry, but can they repeat what they said because I'm a little, I think I got distracted for a second. I'm sorry, but can they repeat
it again for the benefit of Senator Campbell Rodriguez, who seemed to have a difficulty without, not having a timeline set. So it would be useful for her to hear the position of the Bureau that has been carrying the policy.
Okay, thanks again, Minister. So the clause says an employer shall take immediate and appropriate action to deal with the sexual harassment of a worker of the employer when the employer becomes aware of the sexual harassment. And we believe that we have had lots of discussions around this. And when we get to this point, it's because having had all the discussions and all the consultations, this is what we have arrived at because we believe that there is an explicit and inescapable duty of the employer to take immediate and appropriate action because of the nature of sexual harassment and how intimidating it can be to persons, how debilitating it can be to their health, and the kind of impact that it can have on the persons who have experienced sexual harassment. And we also want to send a clear signal to persons who are perpetrators that once this act takes place, that it is not going to be swept under the carpet and it's going to be treated with the kind of intensity, the immediacy that it requires.
So, Minister, are we then saying something that is so egregious, something that we're leaving it to the discretion and we're making an assumption that because it is such a bad thing, the employer will feel the need to act because it is such a bad thing? I don't think human nature allows us that discretion because there are so many instances when people don't act the way they should, even in bad circumstances. And they're not acting is a result of several reasons. It's not because they themselves are bad or they don't see it as a bad situation. But I think if we're leaving it up to just the fact that because it is bad, then they will know they need to act. I'm not, for the record, I'm not convinced that that is enough because what if I wait 3 months to act as an employer? There's no penalty for it and there's nothing to tell me to act sooner. So if we have no penalty for not acting and there's nothing to tell me to act sooner, I don't even have to act.
All right, thank you, Senator Campbell Rodriguez. I recognize Senator Sophia Fraser-Binns, and then I'll come back to Senator Long.
Thank you, Chairman. I understand where Senator Rodriguez is because I'm listening to the debate and I am actually in support of your position, Senator Senator Natalie, because, and I say that because the fact is that immediacy is really, though we want to think it is objective, it really is subject to one's individual circumstances. And if that is the case, then there is nothing to stop an employer from not doing something and then saying, oh, the situation did not arise for me to do it, or I was dealing with other competing matters or other HR issues. There's so many excuses that can be proffered. It is whether or not the tribunal will accept that those excuses are acceptable. But if we have a specific timeline, and I would not go with 7 days at all, I would go with 14 days. If we have a timeline, then what it does, it says that within this period, then the employer must take action. And if the employer fails to take action, then apart from being able to go to the tribunal, there should be other repercussions against the employer. So I understand the position of the Bureau, but I think that in this instance, a specific timeline should be provided for within which the employer takes action.
Can I just clarify then that if, oh, I'm sorry, I'm really sorry.
No, go ahead, Senator Gale. Go ahead.
Oh, sometimes, Chair, a thought will come into my mind, I may very well lose it.
That's all right, we're allowing you.
But I'm just
wanted to respond to me, come on.
No, I like responding to you. And so I would want to clarify in my mind that if in the event that we stipulate with a timeline, if there's a failure on the part of the employer in responding within that timeline, do we pose a penalty? I just want to be clear.
I think we should.
Okay. So it puts the discussion in a different dimension, because if once we establish timelines, there ought to be actions that would support the failure to act within those timelines.
Thanks, Senator Gale. Senator Longmore.
Thank you, Chair. I think my ideal, I think, lies somewhere in the middle here. Firstly, I want to clarify what is the action that we are hoping to see immediately. Why I ask this question? In the event of someone being harassed, the victim is seeking to get an immediate end to that situation. Now, in my mind, I think there should be, within 24 hours, a direct response from the person who the complaint is made to, so the HR department, the employer. Within 24 hours, there needs to be a communication from that person to the alleged perpetrator. Because that is the immediacy that I am thinking that the victim is especially wanting. Now, in terms of the other, the paperwork action, the filing the complaint, the subsequent investigation and probably to even see if there are other victims, etc., etc. That I think ought to have a timeline with the penalties. But again, I go back to saying that we need to make it such that it is reasonable to get it done and done properly. So for me, it is again almost like a tiered approach where there is an appropriately immediate, within, for me, 24 hours communication between the person who the complaint is made to and the alleged offender. Then now, a reasonable time frame, as we may deem necessary and agree upon, that the formal complaint, investigation, etc., happens. And if that does not happen, and also if the within 24-hour notification, that this could be just a quick communication. If those don't happen, there should be penalties. Thank you, Chair.
Thank you, Senator Longmore. Ms. Grant, could you make your comments here, and then we take it from here?
Well, Minister, it really is a decision for the committee to make. As it relates to the policy, it's not something based on my recollection that the policy contemplated the timeline. But then there are instances where we can go outside of the policy if in going outside of the policy, it won't nullify the original intent of the policy. And this is one such recommended insertion that I don't think would nullify the intent of the policy if we were to put a timeline, but it is essentially what is the committee's will and pleasure, is that we insert a timeline so that the employer is unable to deny that he or she acted or did not act, or it really is for the certainty of the victim to be able to say that my complaint was not acted on within this time. It's just to give us more certainty. So it is what does the community, what does the committee want? What do the members want?
Can this matter be looked at by the technical team, legal reform, to come back to us how it's treated in other jurisdictions in terms of a timeline?
I had looked at it. I only saw the one jurisdiction that I mentioned earlier. Only one with a timeline, the 14 days.
14 days.
I didn't see anybody else with that.
Well, that's a matter we can come back to since we're close to the time of wrapping up our meeting for today. But we can make a note there. That's a matter we can make a final decision on when next we meet. Are we in agreement on that? Right? Senator Gale? Yes.
Yes, Chair, I'm in agreement.
Yes. Senator Baines, I see your hand up. Senator Fraser Baines.
Yes, thank you, Minister. I just keep forgetting that Senator Scott Motley had asked me to apologize for her. And I just want to put it on record that she sends her apology for her absence today.
I'm going to tell her that you never acted immediately nor appropriately.
Not appropriately.
Okay. Noted, Senator Fraser Baines. All right, Miss Grant, you have you can just maybe take us now to the.
I can go through the general recommendations quickly. There are not many.
Still look quickly at what the former acting ombudsman sent to us. Just look through it quickly. You have some thoughts on some of the matters. We could just go through that quickly.
Okay, so that, all right. So we would have to finish the rest of the general recommendations at the next meeting. Okay, sure. So I have gone through the 2-page document and I have picked out the heart of the issues. So the first of them being is that what we have listed there in the bill to be examples for sexual advance, that he thinks it is too limiting, and by outlining these 5 things, or the 5 forms in which sexual advance can occur, he says that we are placing an unnecessary fetter on the evolution of the definition of sexual harassment. He further advocated that we expand the definition of sexual harassment to put in the catch-all being other unwelcome conduct of a sexual nature. So let me just look back at what we have here. So to add that to the definition, other unwelcome conduct of a sexual nature, and to thereafter remove the restricting list of 5 that we have for sexual advance. Okay, the rationale for this approach is that we would leave it up to the expert panel of the Sexual Harassment Tribunal to interpret the legislation and to apply real-life experiences, which will have the effect of not closing the categories of what can actually constitute sexual harassment, whilst at the same time ensuring that the evolution of what sexual harassment is does not open the floodgates whereby anything that is raised is given the blessing of the law. So that's the first thing that was said.
Ms. Grant, I don't know if as we look at it, if anyone would comment, because we're really at the end of trying to wrap up to have our report ready. Or would members wish some time to think about it, and when we come back,
Can I, Chair?
now has to be very tight moving forward.
Chair.
Madam
Oh,
Chair.
sorry.
I'm sorry. I'll take Senator Cameron Rodriguez, and then Senator Gale. Yes.
Thank you, Madam Chair. I just said I went through and I just wanted to give my feedback real quickly. He makes a good point under the limiting, and it's not hard to add in other unwelcome conduct of a sexual nature. I think that is not a difficult one in my, subjective opinion. And he's correct. There are things that we may not foresee, and especially because of how things evolve in society. So I would support that. On the second one, where he spoke about the use of the word reasonably, we already dealt with that one, so I think we can easily skip it. The victimization one, which is the third one.
Senator Cameron Rodriguez, let us take it point by point and get the comments of the others.
Okay, so I support the first one about limiting.
Okay, fine. Senator Sophia Fraser-Binns, and then Senator Gale. Senator Sophia Fraser-Binns, please.
Thank you, Minister. Thank you. I wondered though, and the technical team can provide some guidance, because based on what the former ombudsman is proposing, when I look at E, I wondered whether E does not cover that, and whether it will be repetitive. I don't know if Mrs. Celia Brown could provide some guidance in that regard, but I did not think that it was necessary to add that in light of the provision at E.
All right, may I ask for Mrs. Celia Brown to hold her comments, and let's hear from Senator Gale.
Chair, I think we would have dealt with aspects of what he under subjective test already. I would want to go, and I'm sorry that he never made this a submission so that we could deliberate on it and get his feedback like others. Because I'd want to discuss a little bit in terms of victimization and what he really meant in those areas, and so that we could ask him questions. But maybe we have to deliberate among ourselves around that. And I would not want to do it in haste this evening.
All right, Senator Gale, on limiting, what is your comment there?
On limiting? I'm of the view, that what we have there is sufficient enough. The extension of other unwelcome conduct of a sexual nature is going to leave it up to a tribunal to determine, in my mind, if added.
Okay.
That just makes it further expansive.
All right, I'm going to ask Mrs. Celia Brown for her comments here, or the Solicitor General, legal reform.
Chair, I've not had a chance to review the comments that were made. So I would need time to go through it and look at the definitions and then come back to you on that matter.
To look at it, and then the next meeting.
Madam Chair, can I just ask one thing in the review and make a suggestion, because I do understand what Senator Fraser-Binns is saying, that E does allow for it, but what it's still limiting based on what our minds can think of today. The way he has phrased it, other unwelcome conduct of a sexual nature, leaves it a little wider for things that we may not think of today. So they're very similar, but I personally prefer the way he has phrased it versus how it's phrased in the Act.
All right, so we agree that the technical team will look at it, and at next meeting we will get their input and we can make a decision. I do not want us to have long deliberations over it next week. I want recommendations to come next week and a decision made. Okay, thank you. Ms. Grant, you can go to the other subjective test?
Okay, Minister. So the subjective test is, as Senator Cameron Rodriguez said, we have already dealt with it. The thing about the inclusion of the word reasonable and what that does, and we had already agreed that we would take it out because that was really the essence of it, to say we need to create some amount of, it is too subjective and that it would need to be removed. And we have already said that that needs to be removed, taking or cue from other jurisdictions as well. The thing about victimization that is raised here is a good point. He said that he explains, of course, how victimization takes place when a person asserts a right and in response to employer in an employment context responds by punishing the person, for example, by terminating their contract or by failing to pay to that person his or her bonus, etc. The point that he made is that under clause 38 of the bill, it creates a criminal offense. So that is the adverse action clause, which says that a person commits an offense if they subject the first mentioned person to any adverse action, and on the ground that, and it goes on to list. And then the contravention of subsection of subclause 1 rather is dealt with on summary conviction before the parish court. What he said is that victimization is treated as a criminal offense, and any person who is so victimized does not have a remedy before the tribunal. So they are not given a remedy. So they have lost their job, or they have lost their bonus, or they have lost the money due to them, but they don't have any prospect of advancing a separate claim before the tribunal to obtain damages in that regard, because the bill does not create victimization as a standalone complaint. It only recognizes it as an offense that is heard by the parish court. And so the essence of his suggestion is that we create victimization as a standalone complaint that the complainant can bring before the tribunal, as well as to have it criminally dealt with by the parish court. And that's the extent of the suggestions he made. That's the extent, yes.
Invite comments.
So Chair, if you would please recognize me.
I recognize you fully.
So Chair, again, in my mind, what he's suggesting is that this bill makes preservation or a provision for the matter of victimization to be dealt with at the level of the tribunal. However, the concerns or complaints that would have been triggered can be dealt with by another tribunal, because these would now be resulted as employment breaches within your course of employment by virtue of the retaliation that an employer would proceed with. And that would be dealt with at the Industrial Disputes Tribunal, going through the course of the Ministry of Labor, or raising your grievance with your employer. Yeah? What we have to be satisfied with now is that those workers who are non-unionized, the dismissal matters can go before the Industrial Disputes Tribunal. But the question of a victimization in promotion, bonus, if you would have been receiving benefits that all of a sudden would have been stopped or denied, then that is cause for concern. And what we may have to be guided by the technical team is whether or not this tribunal can treat with those matters, or by extension, if there are amendments to the LRIDA to treat with that matter, because I can see the consequential impact that may be created here because of the victimization and the retaliation that may take place.
Thank you, Senator Gale. I recognize the Solicitor General who wishes to comment.
Thank you, Chair. It's not quite true that the victim cannot get compensation. So we don't put it in every law. When someone is convicted of a criminal offense, there was a recent amendment to the Criminal Justice Administration Act, and that amendment deals with award of compensation to victims. So because we've put it in that act, it means that we don't have to keep putting it in every single act. So if someone is convicted of an offense, so if someone was convicted of an offense under this act, under, I think it's clause 38 of the offense of adverse action, the court has the power to look at the victim and see if the victim has suffered any loss or damage and can make a restitution order. And that is done at the same time as the conviction of the offense. So the person doesn't have to go back to court. They don't have to make a civil claim and get another attorney or anything like that. It's dealt with at the same time by the judge. And the restitution order can deal with compensation from, it can be money, it can be attorney's fees and legal costs, it can be other losses suffered by the victim. So it's not quite true to say that the victim cannot get compensation. So I just wanted to make that clarification. Now, the committee can decide though to make other remedies available, and that is something I guess that you could discuss, but I just wanted to bring that to attention.
Thank you, Solicitor General. Ms. Grant, you want to make a comment on that?
No, Minister.
All right. Senator Gale, you're satisfied with the comments from Solicitor General?
I'm still thinking in my mind around the question of the victimization that may take place and how that will be treated. Because it's not only a situation where compensation ought to treat with it, but if the person is dismissed, yes, there is that course in the other tribunal, but if other provisions are denied, then do we take that through the courts? I just want to work in my mind how best to deal with it in terms of an immediate remedy or course.
Senator Fraser-Binns.
Thank you, Minister. I was actually just thinking through it because I do recall the amendment that the Solicitor General spoke about, but I wondered, and you perhaps can advise us, Solicitor General, if you can, how widely used is that? I also was thinking through, again, because this is a groundbreaking piece of legislation, whether there would be any harm, and the technical team can provide some guidance, would be there any harm in putting in the bill a specific provision that allows the tribunal to make an award in that instance? I heard what Senator Gale said, but one of the reasons I have my head tilted that way, Cavan, is I'm just wondering, in such an instance, do you then have to start a separate action in the Industrial Dispute Tribunal for compensation, for victimization? So you probably will end up with 3 different actions, one at the tribunal for sexual harassment, one at the parish court, and one at the Industrial Dispute Tribunal. So I don't have a recommendation, but I'm just trying to think through what would be the easiest way to deal with this matter.
But if the retaliation is one of dismissal, that would be dismissal for cause, whatever, that would have to be taken up before the Industrial Disputes Tribunal. That's clear. But if there are other retaliatory acts that would have been, advanced by the employer, there has to be an avenue for it to be addressed. And it's the question now of how do we protect against that? I still want to work it in my mind, Senator Fraser-Binns, in terms of the most appropriate application, because it is a cause for concern. It's a legitimate cause for concern, and it has occurred.
So can anyone?
I'm right there with you, Senator Gale.
Anyone from
I can give you a remote hug for that.
Solicitor General, can you give us some guidance?
Right. So just to clarify my comments, I wasn't saying that we can't put something, or the committee cannot put something in relation to the tribunal. It's just that a comment was made in the submission, and I was correcting that comment. But to your point, Senator Fraser-Binns, yes, you could put a remedy in that the person could approach the tribunal for, I'm going to say, protection or a remedy to deal with any victimization. What I decided to look at, though, was the Protected Disclosures Act, which some people, the Whistleblower Act. And there are provisions in there dealing with occupational detriment. So I don't know if it is that the committee is thinking that there should be provisions in the sexual harassment bill that would speak to the employee not being subjected to any occupational detriment. And that's defined, and I can explain what it is, because they have made a complaint. And then things could be triggered from that, meaning then that the person could then approach the tribunal to say, I am suffering from occupational detriment, because it may not just be that they're fired, it could be that they're not being promoted, or they have been demoted, or they are, you can have different locations and they are moved to a parish that, it's just very at short notice, very unreasonable. So, I mean, occupational detriment can mean a lot of things. I'll give you an example. In the Protected Disclosures Act, it talks about being transferred against the will, refused transfer, promotion, provided with adverse references, all of that. So it could be that you will look at perhaps allowing, providing for a provision to say that if someone has made this claim, they shouldn't be subjected to the occupational detriment. And then there is even a presumption in that Protected Disclosures clause that says if the person suffers the occupational detriment at or about the same time they had made a protected disclosure, there's a presumption that it's as a consequence of. So that is something that you could put in, or you could consider, and then allow that matter to be, for want of a better word, litigated before the tribunal. So that would be in addition to, but I can't remember now. I thought there was something like that in the bill, but that's what I was looking for, but I don't think I can't find it. So, I see offense of, well, it's an offense. So the issue is what's here in the bill that I see is something that's a criminal matter that you take before the parish court, but this would be another avenue.
I am thinking, Ms. Aldred, where I've seen that before, and I don't think it's a protective disclosure, and I'm trying to work whether it is this bill or OSHA. And the next question I'd like to ask, Chair, if in the protective disclosure, occupational detriment is defined.
Yes, so that is what I was reading, that it includes,
okay.
Right, so it includes an act or omission that results in an employee being, and then it's A to J, subject to disciplinary action, transferred against his will, refused transfer or promotion, dismissed, suspended, demoted, harassed, intimidated, victimized, provided with an adverse reference, a number of things, denied appointment to professional office, say no, the person could be acting and you don't appoint them, things like that.
All right, so I'm just trying to understand, Chair, and I mean, I'm sometimes very slow in understanding.
Oh, shall I say?
But I just want to know, because I can work with that. I just want to know that, so this may happen after the fact.
Yes.
After the fact, not in the course of treating with it, the matter at the before the tribunal, but after the fact. Now, the remedy, is it before the same tribunal that the application is being made because of these consequential impacts?
All right, so that's an excellent question. And I'm going to ask you to give me a few minutes. And I think I know where you have seen this provision before. There was an amendment to the Jury Act. And in that amendment, and that's what I want to look at, in that amendment, it said that the person must not be victimized, for want of a better word, by the employer because they want to go out and do jury duty. And there was, and because you do have, you used to, I'm hoping it's in the past, where you had that situation where persons were not allowed to, or they would dock their pay, or they would threaten dismissal or other punitive action. So there's actually a provision in that amendment. And I just wanted to look back at that just quickly, if you don't mind, for me to just refresh my mind as to my memory as to how it was treated there, because that's a good point of, would you be approaching the same tribunal to indicate that you're being victimized because you have submitted a claim, a complaint before that tribunal?
I don't know.
I'd have to think about that.
I don't mind.
And I'd have to think about that as well.
But it would certainly help us. Thanks.
So you would come back to us next
I'm going
week.
to look right now. Oh, yes. If it's an appropriate time, if it's a convenient time, then sure, next week.
Yes, you could come back to us. You know, we have to cross the T's and dot the I's next week and finalize what we're doing. So if you could come back to us next week with that. Ms. Grant, have we addressed all the points raised by the former?
Yes, Minister, he only made those 3 points, and the next page was conclusion.
Yes. All right. And I really want to thank him for sending this in. I'm sorry he did not make his submission when we were able to sit and have full discussion on the matter, but I felt it was important that we recognize what he has sent to us and that we give some consideration. Yes, Solicitor General, I see your hand. Yes.
Thank you, Chair. I found it. The employee could have applied either to the court or to the IDT for relief. So the scheme is, sorry, let me scroll. An employer is not to punish an employee who has been summoned for jury service, but if the employee feels that that has happened, the employee adversely affected may apply to the court or to the Industrial Disputes Tribunal for relief. And then the relief is either reimbursement of lost wages and benefits as applicable, or reinstatement where the person was dismissed.
Okay. All right. So
and that was a 2015 amendment to the Jury Act.
Yes, yes. All right. So Ms. Grant, you have so noted.
Section 19, big D. And then there's also the Protected Disclosures Act that provides some guidance.
Okay.
That's from our jurisdiction, just as a guide.
All right, excellent. So next week we can make our final decision on these recommendations and what will be included. So Senator Gale, you want to make a final comment on this?
I'm appreciative of the submission that was made by the former acting ombudsman. It has ignited further discussions, and as I've expressed earlier, it would have been good if he would have made the submission earlier, where we could question his mind But these submissions by, external persons to this committee is always very helpful in crafting an appropriate legislation.
Yes. It came in the nick of time.
Yeah.
Nick of time. All right. So I think that we have used up all the time allotted to us, and it has been well spent. So, Ms. Grant, we will pick up next week. We will meet either in the morning or next Wednesday or in the evening. You notice I didn't say afternoon.
Not Wednesday, Minister. There are several meetings on Wednesday. I only have Tuesday morning free, which is the 6th. Tuesday the 6th.
And there is also some hours in the day after the afternoon. You may want to meet in the evening because we have to get this piece of legislation wrapped up and to table our report in a matter of days, not weeks. So I'm appealing to members, if you can make yourselves available Tuesday morning, or if it's not convenient for you Tuesday in the day, you could make yourselves available Tuesday evening. The fact that we're meeting virtually does help.
Minister, for me personally, Tuesday can only be in the morning.
Okay, Solicitor.
But I am just one person.
I was just pointing out that there may be a joint select Tuesday afternoon. Yes, but I think Tuesday morning there is PA. I don't know which one.
I don't think there's an agreement. Sorry, SG. Okay. I don't think members had agreed to meet on Tuesday coming. Based on right, they checks before to see.
Okay, but I think NIDS Joint Select is trying to meet Tuesday afternoon. So I'm just pointing that out.
But it's
Tuesday morning may be available. Am I right?
Yes, Minister.
McCarthy?
Yes, Minister.
Right. And I'm saying for members, we can meet Tuesday morning. Up to what time?
Well, it starts at 1 o'clock. It's 1 to 5.
Okay. Or we can meet, if it's convenient for you, after 5. Can we, Ms. Mack?
I'm not sure, Minister. The members would have to, and I'm not sure the technical team will be available because it would be the same persons in the NIDS meeting, so I'm not sure.
So can we agree then we will meet Tuesday morning?
What time Tuesday morning, Chair?
I would say we could, you want us to do like a 10 to 1?
It would mean that I would have to join that late and I would have to postpone a meeting. So
if you're going to postpone a meeting, you can join us on time then?
No, it means pushing one meeting to another time. Well, the first meeting for me starts very early and it would have overlapped the 10 o'clock. And then I had another one at 10:30 that I'm going to have to postpone if we're going up to 1.
All right. So can we meet at 10:30 or 11 and we go to 1? Because yes, SG, you have a difficulty?
Well, it's just that there are some of us that are also in that NIDS meeting that starts at 1. Well, and it's very difficult for us, like even today, it's very difficult for us to move from one to the other without a break. And perhaps it's lucky that there is no OSH legislation in place. I say that tongue in cheek to an extent, but I mean, some of us really do need even a half an hour break in between the meetings. I think it's only reasonable. So some of us really do have a difficulty moving straight from one right into the other. I was going to make a plea if the meeting couldn't start a little earlier, but I guess, you see, I know I'm not a member, but the technical team, we do have some difficulty from time to time. I have to say, I have to put that on the record. And as it relates to a night meeting, so like some of us like me, I do the meetings from office. There is curfew. There are issues that we all have. Plus, we have already been going through meeting after meeting from morning. So it's very difficult for us to be able to then come out to be able to do another meeting and try and concentrate and deal with these very ticklish issues, because I have to tell you, a lot of the issues that were raised this afternoon, the fact that the committee could not agree to a lot of the things so far and they need more research shows that they are not very straightforward matters. They aren't. This bill is quite, the issues that come up are quite complex because of the kind of emotion that will be evoked with how you deal with them and how you treat with them. So I'm just putting that out there, not a member, but just putting it out there on behalf of the technical team.
You're a critical member of the team.
What is happening Wednesday, Chair?
Chair. Ms. McCarthy?
On Wednesday, there's PAC, and at 2 o'clock, there is also, and I'm the clerk for that, so.
Oh.
Yeah.
So if we were to accommodate Tuesday early, what would be early? What would be the earliest time that we could work with on Tuesday?
9. Normally CDF starts at 9 on a Tuesday. I'm not sure if members would be able to come on at 9.
All right.
So you will make adjustments to
No, I will make adjustments. It's important to conclude this, you know.
It's urgent.
Yes. So I will make adjustments.
Okay, so on Tuesday we will say 9 to 12.
All right.
Technical team a break. Right, SG?
And I bless you, Chair, and I bless all the committee members, and thank you very much. Just to make a little point, we had actually done a little research on an outstanding issue from last meeting, but I guess at the next meeting, we can speak about it.
Mention what that is. Go ahead. Go ahead.
Well, it's really Mrs. Masado. So I think, Mrs. Masado, can you just speak kind of quickly to it? And it actually is very brief about standard of proof.
Okay, good. Hello, Ms. Masado.
Yes, Chair, thank you. As SG said, very brief. We looked at various legislation and we really couldn't find anything in all our research to date about the standard of proof. We found 2 instances where they spoke about the burden of proof, but that's not really relevant to our to the query that was raised, but we have found nothing with respect to the standard of proof. So that was just our findings that we were reporting on.
Okay, thank you so much. Ms. Grant?
Yes, Minister.
Sorry, so Chair, just to explain, it means then that the legislation doesn't usually go into more detail and get granular as it relates to standard of proof.
Yes.
So they basically do what we have done.
Yes. So noted. Ms. Grant?
Yes, Minister.
Yes. So you have noted that, and you will prepare yourself on Tuesday at 9?
9 to 12?
9 to 12.
Oh.
Okay. I really want to thank everyone. And you're okay, Senator Campbell Rodriguez, for that time?
Yes, I'm good. Thank you.
So I want to thank all the committee members who stayed with us. It was a productive afternoon, and look forward to the full team on Tuesday, hopefully. Thanks to the technical team and thanks to the staff of Gordon House, Houses of Parliament, and to Anila McCarthy, who coordinates our session. So thank you so much, everyone. At this point, will someone move?
I so move.
Seconded.
Senator Fraser Binns, I'm going to buy a tin of paint for Christmas.
You might need two because it takes several coats to go over.
Don't you like my bright color? It's spring.
Senator Sophia Fraser Binns with her dull color there. I would say third by. Thank you, everyone. Bless you.
Thank you, sir. Have a
All
good
right, take care. Be safe.
day. Bye.